Welcome to Looking at Legal Stuff. Today we have 20 hearings, including part of a divorce trial, in the case of a couple who split up due to a DV incident that led to Dad spending some time in jail. At the beginning of this case, he's on supervised visitation after he was released. We start this case with day one of their divorce trial, where Mom gives all the background info on why they're getting divorced and how she'd like their assets to be split. After day one, we have hearing after hearing where Mom and Dad will attempt to hold each other in contempt. First, Mom wants Dad held in contempt for not paying child support and allegedly violating a restraining order. It doesn't go the way she wants. Then Dad tries to hold Mom in contempt for withholding visitation with their son, and after he's successful and she's ordered to resume visits, she continues to withhold the child, and when Dad tries to hold her in contempt again, he discovers he can't serve her because she's fled the state with their son. What will a judge tell him to do about this? Let's find out. Hearing number 1 in today's video is from day 1 of their divorce trial. They did not stream the second day for some reason. I've included it in the case to help give you some background in this very high conflict case, but you can skip the first hearing if watching a trial without knowing how it ends is frustrating for you. I would note, now that I've watched the hearings, I would recommend that you listen to it. Mom is pro se and gives us lots of background info on their divorce. We don't hear from Dad's side much during the trial, but we get to hear his side in all the rest of the hearings.
All right, good morning, everyone. If we could go on the record in the courtroom, please.
You are on record.
Thank you so much. This is the matter of Desiree Kamba versus Ruben Kamba, 21-3-0054-208. This is a date and time set for trial. There's someone just in the waiting room that says iPhone. I don't know if we're waiting for somebody else to be here at this moment. Concerned about letting them in because of a few different reasons, but if anybody is aware that there's someone that they're waiting for that may have showed up as an iPhone, please let me know.
And also, Your Honor, for our perspective, given this was set for 2 days and we weren't sure what witnesses or evidence Ms. Kamba would be presenting, our witnesses are all scheduled for tomorrow, so we don't have anybody that would be coming in on iPhone at this point.
Okay. Ms. Kamba?
No, I don't have anybody coming on an iPhone.
Okay. I have received some exhibits from Mr. Baldwin on behalf of Mr. Kamba. I don't know if there's any exhibits, Ms. Kamba, that you filed or at this point?
No,
or...
I did not.
Okay. And do you have a camera that works on your whatever device you're using?
Yes.
Perfect. Thank you. All right. I see that Miss. Hold on one second. I see that Miss Powers is here this morning, and I don't know if the parties are agreeable to just addressing her matters and her portion of this case first, so she doesn't have to be here the entire time, if that works for everybody.
Yeah.
That's fine. And I would indicate after reviewing the worksheets proposed, I don't have any objection. They look to be appropriate and match the information I had on my client's income. So I have no objection to the worksheet proposed and making sure that the proper language is included for the state on any final orders.
All right, Ms. Powers, anything else that you feel you need to share this morning? If there's an agreement there.
Just quickly, I am filling in for Miss Looney today. My understanding is that we had filed proposed worksheets on April 5th. After we filed the proposed worksheets, we did receive updated pay stubs for Dad, which didn't quite match our worksheets. So if the court wants to enter our worksheets, that's fine. But if Mr. Baldwin wanted his worksheets, I did not have an objection to that. And then this child is on state medical through the mother. So I would just ask whatever orders entered, identify that the kids receive state medical benefits through the mother.
All right. Do either party have any questions or concerns for Ms. Powers on behalf of the state's interest in this case?
Is she gonna go back, or how does that all work for child support?
I guess, do you mean like back support?
Right, because I haven't got anything. Me and him have been separated since 2021, and I haven't received any payment for Gabriel this whole time.
The state does not have a position on the start date since our interest is medical only, so the court can decide when they want the start date to be.
Okay.
Okay.
All right. Well, Ms. Powers, if you don't have anything else that you need to add, then you are free to go. I appreciate your presence this morning. Thank you.
Thank you.
All right. So Ms. Camba, you are the petitioner in this case. So you are generally speaking, we'll do opening statements. So each side will have an opportunity to make an opening statement about what they expect the testimony and evidence to be in the case and what you're ultimately wanting out of, as a result of this trial. And then since you're the petitioner, you would then present all your evidence and witnesses first. And then Mr. Baldwin would present on behalf of Mr. Camba after that. Once all those, and then any witnesses that either party would bring forward, each party has an opportunity to ask questions of those individuals. And once all of the evidence has been presented, each party will have an opportunity to do a closing statement and essentially argue for what you're requesting of the court from this trial. Are there any, I have this set as today and tomorrow, so 2 days. Is that any concern for that not being enough time at this point?
I think it's going to be plenty of time.
Okay. Any other scheduling concerns or issues before we get started with opening statements?
Not for me, Your Honor. Because I have my witnesses set for tomorrow, not knowing how much time Ms. Campbell would take if she ends up finishing early. I do have some dockets this afternoon. So I'd ask that we break when she concludes, but I know I'll get through my witnesses tomorrow. At this point, I have my client and 3 others set, one at 10:30, one at 11:15, and one at 1:30 tomorrow, with my client starting the day. So depending on how long Ms. Campbell's testimony is, it could have impact, but I don't see any issue with us completing our witnesses tomorrow and have plenty of time to argue.
Okay. Because this is Zoom, it's a little bit weird. So if you have an objection or a question, I'd ask you to try not to interrupt, because cross-talking on Zoom is even worse than in person. There's reactions. There's a hand that you can raise, so you can raise your hand if there's an issue. If there's an objection, by all means, feel free to put that out there as needed. And then if anybody needs a break, including the clerk, and I am not taking one, please don't hesitate to ask. So with that, Ms. Camba, I will ask for your opening statement, please.
Okay, so my name's Desiree Camba, and what I'm asking for is full custody of Gabriel James Camba, and I guess my property to stay with me. That's kind of it. And Ruben can pay his own debt, and I can pay my own debt, except he needs to get caught up on child support. But other than that, I don't have anything about that to say. I'm going based off of the court papers I turned in to start this matter, which states in there that it asked for a parenting plan, and I wrote one up, and father has a no contact order for child, so there's that. He's also not on the deed to the house, which Baldwin has proven to you guys. And he hasn't made a payment on the house due to him being incarcerated most of the time before we separated.
Is there any property that hasn't been divided at this point, or has most of it been
No,
divided?
everything has been divided besides the house and Gabriel Camba. I mean, I guess he's not property, he's a kid. But those are the only two things that we are technically fighting about.
Okay. I appreciate the outlining really what kind of the basic issues are. So thank you very much. Mr. Baldwin?
Yes, Your Honor. So it's an accurate statement that the primary issues of contention would be the entry of a parenting plan and the division of a real property asset, the residence that's identified in the petition, as well as addressed in our exhibits submitted and proposed. We anticipate the court will hear that during the course of the marriage, a residence was purchased. The title did show it to Ms. Camba, but as the court's aware, our argument is going to be that property is not characterized by title, it's characterized by the date of acquisition. It was a community asset purchased during the community. For the community, there is a debt that is part of the residence separate from the mortgage that's addressed in the evidence. The court will hear a loan was taken out from my client's mother in the amount of $70,000 and paid towards the down payment on the residence to try and reduce mortgage payments. That is a debt of the community that needs to be addressed and paid out of the proceeds of the home. I think it'll be clear when the court hears the evidence that the home was purchased for the community, even though it was titled only to the petitioner. The title itself is not what controls the court's determination of community property or separate property. This is an asset, a residence purchased during the marital community during the time of the marriage. It was maintained up until the point of separation as a community asset. So my client has a community interest in the property. We'll be asking the court to order that the loan obligation be paid out of the property's value, and that any remaining equity be split 50-50 between the parents. As to the parenting plan, there is, and I expect the court will hear, there is a no contact order out of a Cowlitz County Superior Court criminal matter where the child in common, Gabriel, was alleged to or indicated to be present during an incident that is currently in effect because of the timing of some of the materials received. A motion to modify the parenting plan wasn't made because trial was approaching close in time to receiving some necessary documents. We do believe the court will hear through testimony and from the evidence presented that Mr. Camba poses no risk of harm to his child, that even with a no contact order in place, the court should enter a parenting plan with visitation. The burden is going to be on the petitioner to establish any necessary limiting factors. And even if the court finds that there's a basis for any limitations under 191, the court can, under subsection N, make findings that there is no risk of harm or danger to the child as a result of parenting time and allow for visitation. We have submitted in our EO 904 and proposed exhibits, and the court will hear my client has undergone very regular and lengthy counseling sessions that show not just a significant amount of growth and mental stability, but a strong understanding of what's necessary for him as a parent. In addition, he completed all of the conditions of his DOC and probation, and that was also filed as part of our exhibit and ER 904. He poses no risk of harm or danger to the child, and as a result, the court should enter a schedule of visitation that would most likely be in the form of a stepped or graduated plan so that he can be reintroduced into the child's life. The child is about to turn 3 years old, and we understand that it is not likely that the court would entertain a parenting plan that jumps straight to an every other weekend standard plan. But given the evidence the court's going to hear both about Mr. Camba's success and progress in counseling and his compliance since being released from custody, that there is no risk of concern for the child that would require supervised visitation, a period of visitation ordered that would go from regular unsupervised contact to overnight unsupervised contact would be in the best interest of the child, and what we'll be asking the court to enter. Upon entry of that order, we would then go to modify the no contact order to allow for compliance with the parenting plan. So we believe that the evidence that's going to be presented will establish that there is no basis for a limitation on the parenting plan preventing my client from having residential time, and that the residence is community property, that the obligation is on the petitioner to establish that it's not. The title alone is insufficient to do that, and that the house should be determined to be a community asset, and the debt paid out of it and the remaining equity be split 50-50 between them.
Just point of clarification, the protection order is out of a criminal matter that's resolved.
Yes.
Okay. Thank you. All right. So Ms. Kamba, now is your opportunity to present any testimony or witnesses that you would like, and that includes yourself. So do you intend to call any witnesses at this point?
No, but Baldwin was nice, and these notebooks tell me that the client does pot and alcohol and is homeless. So I would like to put that to the court and let you guys know about that. Gabriel is also in special needs now due to the trauma.
Let me pause you for 1 second. So it sounds like you want to testify.
Oh, okay.
Is that fair? Okay. No, that's okay. I just want to ask you to raise your right hand. And I'm going to just swear you in. Do you promise all the testimony and evidence that you're going to present here today is the truth and the whole truth under penalty of perjury?
Yes.
All right. So I don't expect you to ask yourself questions and answer them. You're happy to just speak to me. But I wanted you to make sure that you're under oath before doing so. And then Mr. Baldwin will have an opportunity to ask you some questions once you're done.
Okay.
So go ahead and tell me whatever you'd like me to know.
Okay, so we did buy the house together. The end of October, beginning of November, client went to jail 2 weeks after and didn't work up until like March, April, and then went back to jail. So he hasn't really contributed. And due to the situation that Gabriel has been through, he is now in special classes and is having to learn how to talk from all the trauma he's been through.
Yes, I'll object, Your Honor. Foundation.
Explain to me what kind of classes he's in and how he got placed in those classes, if you could.
So he, like, I would try to walk him around the block and he would just scream bloody murder. And it's not like I was going fast or anything. And so I went and took him to his pediatrician, and he would just scream all the time. He didn't want to talk. And the pediatrician sent him to the progress center. So he is now in classes for behavior because he wants to hit people and scream at you. And also for speech because he doesn't want to use words or cannot use words.
I maintain my objection, Your Honor. We did do discovery and ask for records regarding the child. No information related to this was provided to us in the discovery. No printouts were made of any of these medical records. It's outside the scope of what we were providing in discovery, so I'm objecting to the testimony.
I'll note your objection, and I'll allow her to continue testimony, and my decision will be based on. I'll make sure that I outline what my decision is based on.
Thank you, Judge.
Also, I want to know what the definition of getting in trouble is. Is that like going to jail? Because I almost lost my job because Ruben went to my work.
Well,
and I called the police, but the police were like, well, we can't do anything about it because he left. So what is the definition? Because technically that's breaking it, knowing that's my work. He went out of his way to go talk to my client.
I'm gonna, because this is your testimony, I'm not gonna answer those questions for you at this point in time, but that's information that you're sharing, and obviously it sounds like it's a concern to you. So when you indicated that you want full custody, does that mean you want no visitation whatsoever or no
I
graduated
would like him to
visitation?
do some more than what the court provided with mental health before we talk about that, because due to he just got visitation with his other kids back. So I think he needs more than what they made him do. I think we need to continue. Obviously, he had in these books that Baldwin provided, he likes to drink and do cannabis, and I want to make sure my kid is safe because he also said he wants to kill himself with a tongue ring.
So it sounds like there was some kind of treatment that he had. Are you talking about what as part of his DOC, the whatever?
Yeah, I feel like if
programs?
he can, yeah, I feel like if he can show me actual that he's doing actual stuff, that's like we're keeping track of his mental health, because that was one of the things that happened was he didn't want to take his pills, and that's why mine and his incident happened. So I need more than, I'm sorry, a year, because this has been chaotic for me. I'm now a single parent of 2 kids, and one of them has behavior issues. So, and obviously this isn't his first offense. So we need more than just a year to make sure he is stable enough to be around children, because he didn't just do this in front of Gabriel. Yeah, Gabriel's in my arms, but he did this incident in front of 8 kids or something like that. I had like, my whole house was ready for a birthday party, and this whole incident happening in front of a whole bunch of kids, and I had to put kids in vehicles and ship them off to Amber, who also has a no contact order to him. So I'm sorry, but at this moment, I would have to say he needs more therapy and stuff before we do that. And even if it's supervised, I feel like mentally he needs to be getting checked on more than just the year, because there's nothing in here about 2023. It's all 2022. So I'm still going to therapy through this. So he needs to definitely be going through some therapy too before I would like to go forward with that.
Talk to me about the home. You said that you purchased it late October, early November. Was that of 2021 or 2020? What year was
It was
that?
of 2020. So we just had Gabriel, and yes, it was a communal thing. His mom did help us with the down payment, but yet again, he was not there to help make payments due to he wanted to get in trouble, and then didn't work, and then got in trouble again, and then wasn't allowed on the property.
So if you could estimate how long Mr. Kamba resided in the home after you purchased it?
So we got it in November, October. He was there until May, off and on, because he put himself in the hospital. So he went to jail, dealt with that criminal thing, and then in December went to the hospital for 8 days, and then was in the house up until May. So what, 7 months?
And then this was filed in 2021. Looks like November.
November.
Okay. Are you concerned that you indicated that you want to, he pays his debt, you pay your debt? Is there any debt other than potentially the house that hasn't already been split? Or is there anything of yours that he's paying, or anything of his that you're paying that you're aware of?
I'm not paying any of his, and yes, I've accumulated debt from having to support kids by myself, but I don't even want to fight him on that. I'm sorry. I want this chapter to be done. So I'll pay my debt from the 2 years. I just want him to pay his back child support, and that's it.
Okay.
And I would even be willing to give the money to his mom and give her half, because I feel that it's hers and mine and we could split it, I'm okay with that, but I'm not okay with giving him anything.
So if you were to sell the house, you're willing to split it with his
His
mother?
mom. Yeah, but not him.
All right. Anything else that, I'm gonna just look at your proposed parenting plan and see if I have any other questions before I turn it to Mr. Baldwin. Well, let me ask you about the child support worksheet. So the child support worksheet that was presented by the state, it appears that you received a copy of that. Is there anything about that that you have any questions or concerns with?
Nope.
Okay. And then okay, so your proposed parenting plan that you filed back in November of 2021 lists some child abuse, domestic violence, assault, neglect, emotional, physical problems, and abusive use of conflict. You want to address any of those issues?
No, I think I have, and I think the court has aware of what had happened, and the fact that Ruben has done this multiple times. I feel like the court's aware of what is going on with Ruben.
I do know that you indicated on this that you think he should get some mental health and domestic violence treatment with a parental risk assessment. So it sounds like that's still what you're requesting.
Yes, because I don't feel like you should be able to keep doing this, and this isn't his first offense, and they seem to just be getting worse.
Right.
I'll make my objection to move to strike foundation, but I know Your Honor's already said that you'll consider the evidence of life risk of
I'll note that. I'll note the objection.
Thank you.
This is going to be a great opportunity for me to blow my nose. So hold on one second. All right. Okay. Miss Kamba, any other information that you would like me to know at this point? And I will let you know that after Mr. Baldwin asks questions of you, you'll have an opportunity to give me more information if you choose. But anything else at this point that you would like me to know?
No, I think I'm okay.
All right. Mr. Baldwin, any questions of Miss Kamba?
Just a few, Your Honor. Ms. Kamba, you indicated on direct that the residence was purchased during the time of the marriage, correct?
Yes.
Okay. And it was community in nature. In fact, you had a child from a prior relationship, is that right?
Yes.
And he had 3 daughters from a prior relationship?
Yes.
And then you ended up having a child together?
Yes.
And the residence was large enough for kids to have their own rooms, or their rooms sort of grouped together?
The girls had a room and the boys had their own rooms.
All right. And you borrowed $70,000 from Mr. Kamba's mother for their own home, is that right?
Yes.
And we did send you interrogatories, and you affirmed that as well in the interrogatories, that that there was a $70,000 debt basically on the house from the loan from my
Yes.
client's mom.
Yes, from your client's mom.
Correct. Now, since my client's been out of the home, what's the condition of the home on the inside?
I don't know. I live there still, so I mean, it still works as a house.
Okay.
I don't know how to answer that one.
Okay, so in our exhibits, exhibit number 107 was a market analysis of the home. Did you have a chance to see that in the discovery we sent you?
Yes.
On the front face of the house, there's a window in the photo that is boarded up. Is that still boarded up?
Yep.
Okay. And how long has that been boarded up?
Oh, since July when I got a cinder block thrown through my window.
Okay. All right. And is the rest of the house still in good working order?
Yeah.
Did you have a chance to see the approximate market value on date stamp page 050, part of exhibit 107 for the residence?
Mm-hmm.
With an approximate value of about $290,000 to $310,000. Does that sound accurate to you on what the value of the residence is?
Yeah.
But you don't have your own analysis or anything regarding the value of the home.
Nope.
I don't have any more questions, Your Honor.
All right, based on that, Ms. Kamba, is there any other information you want to share with me?
Yeah, I guess we could talk about the window. His client is a suspect for the window being broken.
I'll object to speculation, Your Honor.
All right. And that was July of last summer, July?
Yep.
Okay.
And it's $1,000 to fix a window.
Windows are not cheap, unfortunately.
No, especially because that was a double pane window.
And was there a police report filed on that?
Yep. The cops came to my house, took pictures, and drove around my house for the rest of the night.
And I'm going to ask a clarifying question because what were the charges for the underlying protection order that's currently in place?
He got an assault 2 for me, so he got a felony and assault 3 to an officer. There was like 6, but I gave him a deal for like 3 or 4 of them. And then he got 3 no contact orders for me, Gabriel, and Amber Ramos. I think there was another charge, but I'm not 100% sure. But I know he got an assault 2 for me and an assault 3 for an officer.
And approximately when did that occur?
May 23rd or May 22nd, around there, because I was having our son's first birthday that weekend.
So May 22nd, 2021.
21.
Okay.
Yeah. And then he got the charges in November. An assault 4 to his ex, who's passed away now, and then got mine in May.
Okay. All right. Did that raise any other questions for you, Mr. Baldwin? I'm sorry.
Not at this time, Your Honor, no.
Okay. All right. If there's nothing else for you, Miss Kamba, want to make sure that I'm giving you every opportunity to present anything that you feel you need to present.
No, I think I'm good. Thank you, though.
All right. And you indicated that you're not calling any other witnesses at this point.
No, I don't really want to have people talk badly about him, because anybody in my corner is going to talk badly about him, and nobody's seen him in 3 years. And I just want this chapter to be done, and I don't really want to deal with all of that. We already know what he's done. So why do we have to keep bringing it up? And I mean, I'm raising 2 kids and they're going to school, and I've had my job for 9 years, and Baldwin presented that. So I feel like I did all I've done.
All right.
I do have one question before we go.
Sure.
Is the Zoom stuff the same that I used today for tomorrow?
That's a great question. I think it will be. It'll be on the website the same, so you'll access it the same way as you did today, and it will be the same Zoom link. But if
Okay,
you have
thank
any
you.
questions or concerns about that, you can always call Superior Court Administration, and they can direct you if it is any different, but I don't imagine that it will be.
Okay, thank you.
Mr. Baldwin, did you want to call your client now, or are you wanting to?
Well, this was unexpectedly short, Your Honor, shorter than I expected, but given, I'll say, the more limited nature of the testimony, I need to maybe have a conversation with my client before he testifies. It does work out. I was having family take a child to a doctor's appointment at 11. But if we are breaking for the day, then I'd be able to do that and still be prepared for tomorrow. Given the length of the testimony, I don't have any doubt that starting at 9 tomorrow, my client will be done by the time the first non-party witness would be coming on to Zoom at 10:30. So that'd be my request. I think the only maybe housekeeping thing is I could formally move to admit my exhibits. I apologize, I already set them down. Exhibits number 100 through 110, all of them except 107 were part of my ER 904. But given that, at least in the testimony, there was no indication that Ms. Kamba objected to or disagreed with the market analysis, I figure that I could move to admit all of them at this point, at least so that they're in the record for tomorrow, and that would streamline some of tomorrow's testimony.
Ms. Kamba, any objection to those exhibits being admitted?
No.
All right, I will admit, 100 through 110.
Yes, Your Honor. Date stamp pages 1 through 179 of my trial exhibits.
All right.
Your Honor, this is the clerk. Can you address the exhibit stipulation?
Yes. Do you intend to, or I guess, Mr. Baldwin, do you want those exhibits returned or destroyed?
Destroyed is fine.
Okay.
I have copies that match, so do all the parties. So I have no objection to the destruction by the clerks.
All right. Okay, well, I appreciate everyone's time this morning. We'll break, and then if everyone could be back here ready to go at 9 a.m. tomorrow. Ms. Kamba, I'm going to double check, but I'm assuming it'll be the same link. Like I said, if you have any problems with that at all, call Superior Court Administration and they'll walk you through to make sure you're here where you need to be.
Okay, thank you.
All right, thank you all.
Okay, welcome to you. And then Mr. Baldwin, you're representing Ruben Kamba, is that correct?
Yes, Your Honor. We filed a withdrawal that was effective yesterday. However, we are here today. There's no proof of service in the file, and I don't believe Ms. Kamba served Mr. Kamba at all. So we're asking it be stricken today. I didn't call it early, but given that other matters appear they might be hearings, I wanted to make sure to address that because it should be relatively quick.
Okay, so let me understand this, Mr. Baldwin. Your request on behalf of Mr. Kamba is to strike the hearing that was noted by Ms. Kamba.
Yes, Your Honor. This was a show cause order for contempt. There's no proof of service in the file. She didn't serve Mr. Kamba. She did deliver a copy to our office about a week after she had received it from the court, but did not serve him, did not file a proof of service. And the order to show cause indicates on the front page, the court orders motion for contempt to go to court on 8/1. It doesn't actually order Mr. Kamba to appear. We did inform him of it, that even though we were withdrawn, we would be here today to ask if he's stricken. She can bring noted on with the proper forms, but that there's a deficiency.
Thanks. All right. Ms. Kamba, so it looks like you filed some paperwork regarding a motion for contempt. And it looks like I want to ask if did you file an order to show cause upon or to Mr. Kamba saying, hey, you're ordered to hereby to appear and signed by the court?
No, I wasn't told I needed that. But when I went online, I printed everything out that I needed and nobody said I was missing anything.
Okay. Yeah, the one issue that Mr. Baldwin properly raises that there needs to be what's called proof of service, that a person that's alleged to be in contempt is given notice of, the full allegation, and then there's an order that needs to be served upon them. And once that order is served upon them, then the person who serves them, which cannot be you, files a declaration or of service, basically says on such and such a date, I gave to person X, Mr. Kamba, this document, and then that declaration is then filed with the court. So that way the court knows that Mr. Kamba's got notice, and then there's a certain time frame also that needs to occur from the timing of the service until the court hearing is heard, and that gives enough time for Mr. Kamba to respond, and that gives you time to reply to his response. So you could look up local court rule 88 that gives you the time frames for that purpose as far as setting a proper time. So do you have any questions about that?
No, I guess we're just gonna move forward, right? Because I can't say anything then.
Yeah, at this point, the allegation is related to the child support, but since there's not that proof of service, even if you said a bunch of stuff today, we wouldn't be able to decide the issue today because Mr. Kamba hasn't been properly served and noted up. So the request is to strike the hearing, which I'm inclined to do, and then you could work on getting Mr. Kamba served with the paperwork, filing that affidavit of declaration, and then getting a date set.
Okay, so can I put him in contempt for 2 months then? Can I do that? Because then it would be back from July and June, or do I just do one at a time?
You can whatever you desire. You can do whatever you feel that whatever you feel the contempt is. You can put that in writing, and then he can respond to it.
Okay, one more thing. Is Baldwin a part of this now, or is he leaving?
He filed a notice that effective July 31st, he's withdrawn. He looks like he's making a courtesy appearance today, but he's no longer representing as of July 31st, Mr. Kamba.
Okay.
So that's where we're at. So we'll strike it, and then we'll leave it to you. If you want to pursue the contempt, then you can go ahead and make sure you follow all those proper steps with notice and the declaration.
Oh, I will. I'll be back.
All right.
I have number 9. Do I have Desiree Kamba with us?
Yes.
Okay. And do I have Ruben Kamba?
Yes, Your Honor, I'm here.
Okay. I'm going to go ahead and open up your digital file. This is 213-0054208. I do think you supplied orders, so give me just a minute. Mr. Kamba, did you receive the proposed contempt order that Ms. Kamba filed?
I did.
Okay. So, first, I'm just going to start out by saying, Mr. Kamba, it looks like you have filed a motion for contempt that you've set on our September 6th docket.
Correct.
So we're not going to hear that today because that is now set for September 6th. What I have on my docket today is a request for contempt based on about $4,000 owed for past child support. Is that correct, Ms. Kamba?
Yes.
Okay. So, Mr. Kamba, I did see your response that you're having some of this withheld from your check.
Correct.
So what else can you tell me? That was just, you submitted about 2 sentences in support of you being in compliance with child support. What else can you tell me?
Well, a payment was made, I believe, on the 19th, that was taken out of my paycheck, and so I'm not really sure what it is that she's trying to get out of here. Yeah.
So Ms. Kamba, you're alleging that since, at least according to your motion, since November of 2021 to June of 2023, that Mr. Kamba hasn't paid $225 a month.
Yeah, so we went and got about 2 years ago, he assaulted me, and we finally just got all of that done in the end of May, beginning of June. And they gave him orders to start paying child support, and he owed back child support from November. And then he said when we were in court that he had a job, and so I waited and waited, and June came and we finished up court and he still didn't pay, and I brought that to the court's attention to make sure that he is not waiting on proceeds of the house. And the judge at that time said that no, he is supposed to be paying. And so then I put in more orders because he obviously did not pay me. And looking at my account right now, there's no money in there from DSHS, and they have my information. So I messaged the guy who's representing us. His name's Daniel or David, something like that. And the last thing he sent me on August 15th was there was no payment received from him. So I'm just asking that we put the supervised visits on hold due to they cost money. And if Mr. Kamba is already behind with one child, Mr. Kamba also has 3 other kids he needs to probably pay child support for too. So I think that putting him in jail isn't going to help, and giving him more fees isn't going to help. So if we put these visits on hold, hopefully then he could get caught up on child support for all of 4 of his kids.
Mr. Kamba, there is a June 2nd, 2023 order for support that was issued for $225 a month, dating back to November 2021.
Yes.
So what can you tell me about your attempts to start paying on that?
So I had given my previous employer the information for taking out child support and the notice about that. I contacted the child support payment agency, and they never reached out at all. And then so I figured, okay, well, I'm in the middle of switching jobs, so I just got another job, and still nothing was done about it. So I had to get a hold with them. So I've been in contact with child support,
Okay.
and they finally were able to get the information from my current employer to be able to have the withholdings, and they said that they should be taken out of this next paycheck.
Okay.
So my last paycheck was about $300 shorter than what I would normally get.
Okay.
And so they're taking $100 out on top of the 225 that were put on there, and so I'll be paying $100 extra on my back child support, and then the original payments of $225 a month.
Okay. So let's do this. I'm going to give you, since we already have a court date set on September 6th at 9 a.m., I'm going to reserve ruling on this contempt. What I need by September 6th is some sort of documentation from you or the state or your employer showing that you are making progress on this. If I don't see that, then I am going to entertain a motion for contempt. I likely will make a finding of contempt if there's no payments made by September 6th on the back support. I'm not going to withhold visitation for child support, but the other tools the court has are not ones that you're going to love. So I really recommend that by September 6th, sir, you have been making payments on those support amounts.
So they had the wrong information for my employer, so I couldn't do anything about that.
So you're gonna have to fix all of that, and you're gonna have to have made payments by September 6th, or I will, in all likelihood, make a finding of contempt, which usually does include interest. It can include jail time. So I would prefer not to go down that road. I would really encourage you to start making payments on that amount.
Okay, so can I make a payment today and then?
Please make as much and as many payments before September 6th as you possibly can. Ms.
Okay,
Kamba, what did you want to say?
Is there any way we can move court from the 6th to the next following week?
Mr. Kamba, would you be in agreement to put this to the 13th? That would give you more time to be making payments.
well, I mean, like she said, I have 3 other children who are, of older age.
I'm asking you, we're running short on time. Can you move to the 13th, or do you want to stick with the 6th?
I'd like to stick with the 6th because I wasn't given very much notice for this court date. So I'd like to stick with the 6th if possible.
Ms. Kamba, is there a reason you can't participate on September 6th?
Yeah, our son has a medical appointment in Portland that took 3 months to get.
What time is that appointment at?
9:45.
Okay. That does run directly into this court date. So Mr. Kamba, that is good cause to move both of your court dates. It's your child. So Mr. Kamba, I'm going to move your show cause motion and review of the contempt to September 13 at 9 a.m.
Okay.
That's it for us today.
Okay, thank you.
Thank you both. Okay. So let me first ask the parties, are you both seeking to move forward on this? Has there been any change in circumstances since we were all last together on August 23rd? I'm
ready to move forward, Your Honor.
I'm ready to move forward as well, Your Honor.
So what I'm first going to do is go back to our August 23rd hearing. At that time, the first thing we'll address is the child support payments. They had been ordered since June. There was some indication that Mr. Kamba was in contact with child support, and they were going to be taking some arrears, as well as making the original payment. So we reserved ruling to see what we could find out about child support payments. What do we know?
Dennis, our child support person, sent me a new table or whatever you want to call it, saying how much Mr. Kamba is behind. He still has not made a payment.
Mr. Kamba, what can you tell me about your child support payments?
I was emailed on Monday by Dennis, my child support agent, saying that a payment was processed, but the payments that have been taken out of my check prior to this process payment still was not sent through. So I contacted my attorney, or not my attorney, my employer, and they said that those other payments were processed on Monday, that they're moving forward.
And Ms. Kamba, you're saying you haven't received any of those payments?
No, and I got my statement from Dennis on the 6th of September, and it didn't show that he had paid anything, and my account that we have set up still has nothing in it.
I am seeing here an email with the support enforcement officer discussing a mistake with a missing payment, and that they were going to get a hold of the payroll.
It's muted. I can't hear anything.
Oh, Mr. Kamba, can you hear me?
Um,
Mr. Kamba, can you hear the
I don't
court?
know what's going on. I can't.
Mr. Kamba, can you hear us still? I'm going to send a message to Mr. Kamba. Oh, he logged off. We'll give it just a minute.
Hello?
Yes, Mr. Kamba, can you hear the court?
I can hear you now, Your Honor.
Good, good. Okay. So I understand Ms. Camba's frustration because she's just not seeing the money. I do at least have an email from Dennis at DSHS stating that they're working on figuring out what is wrong with the payments and that they contacted the payroll department on 9/5. Do you have an update since September 5 on those payments?
Yes, I actually tried to serve or had somebody try to serve Desiree with the new papers and you know, and on the 10th, on the 11th, multiple times just to get her the information, but she did not answer the door.
Okay, but so what, because I don't have those papers, what new papers do you mean?
So what was the question again? I'm sorry.
So the question was, what you have given me is an email from September 5th saying DSHS was going to look into why the payments weren't going through to Ms. Kamba. So from payroll. So what's happened since then?
Well, I got that email on Monday from Dennis, and one payment has gone through of the amount of $225, which is supposed to be the payment for the whole month.
Yeah.
But since talking to my employer, they've been taking the full month payment every paycheck. So instead of paying $225 a month, they've been taking out $450 out of my paychecks a month.
Right. And so, and Ms. Kamba, you're not receiving any of this, is that right?
Right. And I've been in contact with Dennis, who sent me an email on the 6th saying that we have $0 showing in even his account.
So here's the hard place I'm in. Mr. Kamba did provide his payroll stub that shows year to date garnishment for child support of $675 and a current garnishment of $225, which would track with what's supposed to be happening. So I think at this time, the best I can do is have you all spend another week working with DSHS to figure out why is the money leaving garnishment like it's supposed to. So Mr. Kamba's employer is doing the right thing, but why is it not getting to Ms. Kamba? So I think under these facts, I'm going to continue to reserve on the contempt because I have enough in front of me by way of the payroll records that shows Mr. Kamba's employer is withholding. So now it's just, why are you not getting it?
Okay.
So I'd like to still continue to monitor that issue, but it probably is going to take some frustrating phone calls to DSHS to figure out why you're not getting the money, because it is being withheld from his checks. Okay. And then let's talk briefly about Mr. Kamba, your motion for contempt against Ms. Kamba for visitation. Is that something that you want to move forward on?
Yes, please, Your Honor.
So my understanding is your motion for contempt is that on July 18, Desiree did not take Gabriel on the scheduled visit. Then on August 1st, the scheduled visit was shortened. And then on August 8th, there was a missed scheduled visit. I do have a response from you, Ms. Canberra, stating that you fully admit that you missed a visit on July 18th. You misunderstood the game plan that was going. Because of this child support issue, you've had to get a second job, so you have less free time. The week of August 18 was missed due to Gabriel starting school on August 16th. And by that time, there wasn't time to change your work schedule. Since then, you guys have figured out a time and date, and now appears to have this visitation worked out. Does that sound correct to both of you?
No, Your Honor.
Okay, let me ask Ms. Kamba, is that correct based on your understanding?
Yeah, I've made it to all the appointments that the Reconnecting Families has scheduled now.
Okay. Mr. Kamba, what's your take on that? Do you not believe that this issue has gotten resolved?
No, Your Honor. So when I started my job, I was supposed to be working, the hours that I was scheduled for, with Desiree providing only a certain amount of hours, or that I'm able to see my son on Sundays. I was supposed to work during that time. And with that being said, Desiree she was supposed to provide a list of people that were supposed to be able to be, watching me when I'm with my son.
Mhm.
And she has not provided that.
No.
But the day Sunday when I'm supposed to see my son works for her schedule, but it takes a day off of my paycheck as well. I'm willing to see my son any day that possible. But if she's saying that Sunday is the only time that we can make that happen, I'm still having to take time off of work and still make payments for the visitation, not even the full 4 hours that I'm allotted a week, but I only get 2 and I have to pay for them. That's hard to pay. What was that? $340 a month to see my son for 4 hours. If she was really concerned about payments or any concerns about scheduling, she would not try to make it so that I can't attend all my days at work.
So,
and also on that.
okay, so let me ask this, and sometimes I feel a little bit more like a mediator than any sort of judicial officer, but my goal really is to help you all work through a contentious situation for the best interest of your child, okay? So in that regard, right now, so we understand Ms. Kamba has fully admitted that there were some scheduling issues with her work, in part probably due to the fact that she hasn't had child support money coming in because of this other mistake that's happening between your employer and DSHS. So I take that into account. But sitting here today now, do you all have a schedule that works for RF?
No.
Yes. I'm available on Sundays and Gabriel. It's based off of Gabriel's schedule due to Gabriel going to school now.
And Mr. Kamba, you're saying Sundays don't work for you. Is that correct?
That is correct, Your Honor. They do not work for me.
So what would work, taking into account that your son is in school now?
So that I could have my evenings with them. I would be after school on my days off.
But I don't know, do they offer the services at that?
They do, but I can't do evenings due to me having a second job because I'm not getting this child support, and I don't get off until 6, and then she will not have him be there past 7:30. So then he loses even more time. And that's why I've rearranged my whole schedule and gave them all of Sunday.
And Mr. Kamba, what is it about Sunday that you can't rearrange your schedule for?
Well, I have rearranged it for, and my employer is not happy with me not being able to work Sundays, which is one of the reasons that I was hired on with them.
Okay.
And like I said, well, I have evenings off from 7 and, you know, after 7, but that's a bit late for my son. So on the days that I could have them during the week, I would request the whole day off from work so that I can dedicate that day to my son.
So here's my thought. So Ms. Kamba, once child support, whatever's happening with child support gets resolved, will your schedule free up where you don't have to have that second job in place?
That would actually have to be like if we can make sure it's coming in, because Mr. Kamba has a record, right? So I don't know how long that's going to take, but if yes, if it comes in.
She likes to bring this up all the time.
Mr. Kamba, please don't talk over. I'm going to come to you next. Don't worry, you'll get a chance to respond.
But he has a record of not paying child support. I've paid for his other kids before. So if he can continue to make payments regularly, then yeah, my schedule would free up and I wouldn't have to have a second job. But at this time, I can't rearrange it anymore because I'm supporting this kid and not getting child support.
Right.
And Gabriel going to school and having activities on Saturday that Mr. Kamba is not allowed a part of because of the no contact order. Sunday is the only day that works for Gabriel.
Mr. Kamba, what did you want to say? And then I'm going to wrap this up. We're already about 15 minutes over docket ending.
Well, I want to know when it is that I get my unsupervised visits with my son, because I should be having supervised visits where I don't have to pay for them, which she was supposed to provide a list of people. She never did.
Yes,
and
I did.
want to know when phase starts.
Yeah.
Phase 2 starts.
Yeah. Now, Mr. Kamba, you're bringing in, all you have put in front of me is a contempt request based on prior missed visitation. You have not put in front of me any request to do any sort of future scheduling or change to visitation scheduling. So what I'm going to do is set you both on both contempt issues. We'll set over to September 27th. I'm just being handed okay, thank you. I would first, I think we need to take this in steps. We first need to get the child support money that is owed and ordered to Ms. Kamba. So we need to figure out where that disconnect is occurring. Once that money comes in, then I think we can have a rational conversation about realistically what can visitation and reunification look like if Ms. Kamba doesn't have to have that second job. But I'll say, if both parties come back to me and say, well, because of my work, there's no day that we can both agree on, then I'm going to have to order a day, unfortunately, and it's going to put someone in a bind. So I'm imploring you in the next 2 weeks before we come back together to perhaps work on what that schedule could look like, taking into account the best interest of the child. Is that understood?
Yes.
Okay. So at this point,
I'd
hold on.
have no way of contacting her.
That's fine. What I'm saying is you're hearing what she is saying here today about her schedule and Gabriel's schedule because of school. So perhaps it's a conversation you need to have with your employer about what you could make work. The more reunification counseling that occurs, the more likely it is that the unsupervised visits occur. So I want you both to come back on September 27th with some sort of better indications to me on how to make this work for Gabriel, not just for the two of you. But I think before we even get to that point, Ms. Kamba needs to have the child support money coming in. So let's get that issue fixed and addressed. I'll see you both back on the 27th, and I'll reserve ruling on both of your cross contempt motions to that date when we have more information. Okay.
Okay. So just keep doing what we're doing with the visitation as it is.
As it is right now, yes. Okay, so September
thank you.
27th, 9 a.m. Mr. Kamba, if you also want to reach out to your payroll department to see if perhaps they're sending it to the wrong place, that might be helpful because based on the pay stub you submitted, they're clearly deducting it like they're supposed to. So maybe check in with them as well, okay?
Yeah, they've been taking it out, and one of the payments did go through. Like I said, with my child support.
Right,
Did go
so the
through.
problem is it's not DSHS isn't seeing it. So I would hit this on
If
all
she checked
ends
today,
because,
she would see it.
yeah, the more that you get involved in this process, it's much less likely there's going to be any sort of contempt on this issue because clearly your employer seems to be doing what they're supposed to be doing, but I would check with them to make sure it's getting to the right place. Okay.
Yes, of course, Your Honor.
All right. We'll see you back in 2 weeks. All right. Thank you both.
Thank you, Your Honor.
Thank you. And then did we have go to, this is numbers 11 and 12 on our docket. This is Desiree Kamba and Ruben Kamba.
Yes, I'm here.
Okay. And do we have Ruben Kamba with us?
Oh, son of a. David, I have a number of exporting matters, Your Honor.
If Ms. Westling, you need to mute yourself. I'm just going to mute you. Folks, if you're not actively in front of the court, please mute yourself. Okay, so when we were together last, Mr. Kamba was present, and I reserved ruling on the contempt because there was an issue of whether Mr. he claimed his employer had been garnishing, but Ms. Kamba hadn't been receiving it. So I was giving you all time to work that out. We'll talk about Mr. Kamba's motion for contempt, but he's not here. So I probably know the outcome on that case. So Ms. Kamba, as far as your motion for contempt on the child support payments, where are we at?
I mean, he's still behind a lot. Dennis hasn't gotten back to me, but Dennis did get a hold of me after I got out of court and say that there was something going on with his work due to him having multiple child cases going out. They had to figure out which child support needed to be taken care of. So they have figured out that all situated. So I have received payment. So I was willing to give him until like October, the end of October, to make sure he can consistently make payments before, I went further with this contempt, because I understand that if he was trying to make payments and due to him having 4 children and child support trying to take it out and figuring out which kid it goes to and it all a big mess and now it being fixed, I'm not going to be like a total rude person, and I understand. So if he can continue to make payments through October, then I would like to dismiss, I think that's the word, this contempt, because there's no reason for us to keep going.
Okay, so you had, in your original motion, you had indicated there was about $4,000 owed in child support. Has all of that been paid, or are you just kind of slowly receiving money?
Oh, I'm just slowly receiving money because 2 years ago he assaulted me, and then he decided he just didn't have to pay for Gabriel. And then finally we got divorced, and they finally put it in orders that he had to start making payments, and he still didn't. So that's why at that point I made contempt.
Okay, so what I'm going to do on your motion for contempt, since he has made some payments, but not all, I'm going to continue to reserve ruling until we get to a next court date. How far out were you recommending we review this to decide if you want to dismiss your contempt motion?
I mean, now that everything's situated and hopefully his work is going well, I mean, he's not here to answer any of these questions I have. Maybe till the end of October.
Okay. Let's do, let's set this for November 1st.
Okay.
That'll give 5 weeks for you to figure out if this, if you're actually continuing to receive money. So I'll reserve ruling on your contempt motion to November 1st. And then I'm just going to go to his contempt motion, which appears to be allegations that you've withheld visitation due to child support. I'm going to go ahead and deny this motion since he is not here.
I didn't even get that.
Oh, well, I'm going to deny on 2 grounds then. If you haven't been served, it's not properly before me, but also he has failed to appear today.
Yeah, the only one I got is that I missed the days where I first started and I wasn't understanding what was the plan, so I missed that day. And then Gabriel started school.
It's okay,
and
ma'am. I don't need argument on it because I have signed off on a denial of his motion for contempt due to lack of service and lack of appearance today. Okay, anything else you need from the court on your matters?
No, what time is court on November 1st?
Same time as we started today, 9 a.m. It'll be the
Okay.
same Zoom docket, family law, self-represented A.
So Des talk, let's get real for a minute. So to all the people out there who get in a relationship with somebody and somebody says, oh, somebody's keeping them from my kids, and you go to court with them, that's fine and hunky dory. But like actually listen, or we have the ability to get background checks, minutes, like actually do a background check. And so when they say, oh, she's just making me say this, or she's not allowing me to see my kids, she's being so difficult, or he's being so difficult, I don't get to see my kids, da 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 da. Hey, you know what? Look them up. I will. I learned my lesson, honey. Background checks are way cheaper than having a kid with the wrong person. Okay, thank you.
Okay, yep, you're welcome.
Did someone say something?
Yeah, this is Ruben Kamba.
Yep, we are coming to your case next.
Oh,
Let's talk. Let's get real for a minute. So I need criminals to answer this question. So my ex was so close to the finish line where I have to eat my words and somebody's got to prove me wrong, right? So close. The judge is on his team. The supervisor from the supervisors are on his team. Everybody's rooting for him. I'm over here still not. But that's still not the point of the story. I'm like, coming to terms with, hey, if he's going to be a dad, let's do this. I get it. Sometimes, it just don't work out, but he could be a good dad, right? So what? Explain to me. You got a month, right? A month left. And your dumbass shows up to a soccer game where there is a no contact order with me and a no contact order against our son. Why? And then today is Sunday and you were supposed to see your kid today. Why? Please, I need a criminal to explain to me why. You're so close. Everybody but me. So Des talk, let's get real for a minute. So I'm in court, which, goes back to all my other videos. Anyways, I'm in court and my ex wants to be rude to the judge like he usually does. But this time we're in person and then he's like being rude and attacking me. And so then I get to get escorted out by a sheriff. You know how embarrassing that is? So I have to sit there like a little kid. Hey, and then a sheriff has to walk me out. Like, that's horrible. Girls, please, men, please pick good people because, like, that's nuts. It's not even like, oh man, like, we didn't work out. It's like, this guy's psycho and I have to get escorted by the cops to even leave court. That's sad.
thank you.
Yes. Let me just get there. Okay, do I have Desiree online? I haven't seen Desiree logged in yet. Mr. Kamba, have you had any contact with Desiree?
Not at all.
Okay. Okay.
Mr. Kamba, we're gonna come back to your case. This is 213-0054208. I am not seeing Desiree Kamba. I have not seen her logged in since we started this docket at 9 a.m. I am looking for service.
She was served via mail. I don't have a return on the service.
Yeah, I'm not seeing any. I'm seeing your most recently filed declarations and your motion, but I'm not seeing your order to show cause for contempt is for the November 8th docket. You have one order to show cause that you filed for the October 1st docket, but I don't have any service indications on that one.
Yeah, she doesn't answer the door for anybody that I send to serve her,
Okay.
and that's why I tried to do the mail.
Yeah, so what you do need to do is whoever is trying to serve her, so you can't be the one to serve her. It has to be a disinterested third party over 18, someone unrelated to this case. You can have the sheriff's office do it, or you can have a process server do it. If they are unable to personally serve, they file that with this court stating they were unable to serve. That way, after you have tried to have her served personally, we can then approve service by mail or other alternative means. But today, hold on a second. So today I'm not able to move forward with your motion because I don't have proof of service on her and I don't have a proof of attempt of service on her.
So can I say something?
You can.
I've had maybe 4 different people try to serve her. She refuses to answer the door.
Okay.
I believe you denied her supposed me being in contempt and breaking a restraining order. She claims that I broke a restraining order, and then since last month, not October, but September, she hasn't let me see my son. And I just haven't seen my son this whole time.
Sir, hold on. You can, I will let you speak. The problem is I can't hear the substantive issues of your case if you haven't served her and she's not here. So I understand your concerns. What I'm telling you is I can't move forward with those concerns until you serve her and she has the opportunity to respond to your motion. So you're telling me that people have tried to serve her. They need to file affidavits of service or non-service with this court so that under penalty of perjury, I have a statement showing who tried to serve her, when they tried to serve her, and what they tried to serve her with. So what I'm going to do today is strike the 2 dockets that you have scheduled for today, and I'll have you renote those with the court and serve her. And then proof of service needs to be filed. If you can't personally serve her, you will need to file proof of mailing. I don't even have that.
So you said it's an affidavit something?
It's called an affidavit of service or a certificate of service.
Okay. So the people that have tried to serve her, they just have to fill that out and give the times and dates and that her car was in the driveway and all that stuff.
So I'm going to tell you, they do need to file with the court under penalty of perjury their attempts at service. If you are asking me to approve service in some other manner. Okay. So I'm going to strike your hearing for today. You can renote it with proper service. You're still on our docket for next week, and I don't have service of those documents either, just a heads up.
That's with Desiree, correct?
Correct.
Okay, so am I gonna
Sir,
have
that's
to?
all,
Okay.
that's all I have time to tell you today. I can't move forward. I can't hear anything more about your case because the other party hasn't been given notice of today's hearing. Okay, so please make sure she is served, or that people file proof of inability to serve, and then renote this for a docket once that's occurred, okay?
Okay.
Thank you.
Okay, and then let's call number 4 on our docket, 213-0054208. Mr. Ruben Kamba, I have you on this matter. And do I have Desiree with us today?
I don't believe she's here, Your Honor.
Okay, so Mr. Kamba, when I was reviewing this file, I did notice at our last hearing, I struck the matter because there was no proof of service. You indicated at that time she had been served by mail, but I'm still not seeing any proof of service or mailing. So that would, to me, explain why she is not here. Can you let me know how she was served or if she was served?
Oh, well, we tried to certify with, or we tried to serve her with certified mail. She also had multiple people go try to serve her at her house. Also, like, her vehicle's there and people could hear them talking inside, but she just doesn't answer the door.
Okay. So when that happens, if someone attempts service, then what they submit to the court is proof of an attempt of service, even if it is unsuccessful. So I don't have any of that from you. I don't have proof of attempted service. Last time you were in front of me, you told me that you had mailed her the documents. I don't have proof of service of mailing. I don't have an affidavit of service of mailing. So I still cannot move forward. She's not here. It leads me to believe she has not actually been served.
Yeah, well, it was a certified mail and we haven't gotten a return of a receipt of service or whatever that's called.
Okay. So all I can do today, sir, because I have absolutely nothing in the file to document even an attempt at service, all I can do is what I did last time was strike the matter. You can renote it and file proof of service at a later date. I'll also, hold on 1 second, sir. I'll also note that you have filed a new motion and order for contempt that, excuse me, I strike that. She has filed against you an order for contempt where you all are here November 22nd.
Yeah, and that was
has that been served on you?
That was never served on me.
Yeah, I don't have proof of service of that one either.
Yeah, so I found out because I haven't seen my son in over a month. She hasn't been taking him to our scheduled
hold on. Yep, sir, I can't hear the merits of the case because the other party is not here and you haven't served them and you haven't filed a proof of attempted service. So again, all I can do, much like last time, is strike the matter and strongly encourage you to make sure when you come back in front of this court and you want this motion heard, that you have filed with me a proof of service or proof of attempted service.
Okay.
Okay.
And that's all it's called, as far as the paper in the court, because I'm just doing this by myself. I'm not.
I understand, and I can't give you legal advice, but what I can tell you is the court needs to have some indication of how you have served, when you tried to serve, whether it was effective, and all of the service needs to be done by a non-party over the age of 18.
Okay.
Okay.
Yeah.
If you want, There are, I believe it's Mondays from, is it noon to 2 when
Yes.
legal aid is here? I will get it right one of these days. Mr. Kamba, here at the courthouse, we do have legal aid in the courthouse on family law matters from 12 to 2. If you want to come by and ask them questions about service, they can chat with you about that and provide legal advice. And it's free to you.
Okay, thank you.
Okay. All right. Thank you.
Hello, it's Des Talk. Let's get real for a minute. So I am like counting down the days until I'm out of Washington. I'm so excited. So excited. Anyways, let's talk about what's been going on in my life. So my ex is like not smart, and I think we're all aware of that. Anyways, his girlfriend is now banging on my door to try to service me court papers. Oh. Yeah, I'm gonna go with no. Because I guess now I'm gonna have to file charges against her. Just leave me alone, please. Please. God's got a plan for you to leave me alone. Please leave me alone. Please, I'm on my knees, I'm begging, leave me alone. Anyways, have a good day. The sun is out in Washington. And so that's wonderful for like once. So enjoy whatever weather you have. Just know you're blessed. Somebody's obsessed with you.
213-0054208. Desiree Kamba and Ruben Kamba. Do I have you both with me?
Yes.
Okay.
Yes, Your Honor.
Okay. Let me jump into that file. We have new contempt motions scheduled for December 6th that Mr. Kamba has filed, but what we're here on today is Desiree Kamba's motion for contempt dated November 1, stating that Ruben broke the no contact order by sending mail to my house. Ms. Kamba, is that what you're wanting to proceed on today?
Well, there was two in there. There was that one that he sent mail to my house, and then that he broke the no contact order on September 30th at the YMCA.
Okay. Have you served him those documents?
Yeah, they were all together.
She has not served me, Your Honor.
Well,
I didn't serve him. The
Hold
police
on.
did.
Okay, I don't see an affidavit of service of that motion. So when we were here on November 1st, we kind of had the same issue. But at that time, it was Mr. Kamba who had not served you. And so you were not here, Ms. Kamba, because you had not been served. So I struck the matter and asked him to renote it and file proof of service. Then on that same day, November 1, you filed a declaration and an order to show cause for today, but I have no proof of service, and I don't have any reason to believe that he's received it because I don't see a response. So again,
Your Honor, I did go into the courtroom and found that we had court today, and I
Right.
paid to get the paperwork and everything, and I did file a response yesterday.
and she hasn't received that response, I assume.
No, and I paid the police to do my work.
Okay. Well, I'm just telling you, I don't have the proof of service, and he does have to be personally served with this. And
Right.
I don't have any proof of that. So I am going to strike today's contempt hearing as well. You will
Okay.
have to renote it when you can provide proof of service to the court.
So I have a question real quick. Do you know how long it takes for the sheriff to give you back your papers?
It shouldn't take long, so I don't know. I would have no way to know that, except it should not be very long.
Okay, because I mean, I gave it to them like literally after I got your signature or whoever's signature, And I called them and they gave me 2 different response. So I didn't know honestly if he received it or not, because I went there and they couldn't find my case. And then I called them later that day and they were like, oh, well, we're out doing it now. And I was like, okay. So I didn't know what was going on with it.
Okay. Well, and I'll just, so yes, I can't move forward on your motion today until I know that he's been personally served and
Okay.
have that in the file, proof in the file. Similarly, you all are set for December 6th right now on Mr. Camba's motion for contempt against you. But similarly, I don't have proof of service of that motion. So I'm just giving the party a heads up that we're kind of in a position where you all are on my dockets almost weekly or every other week, but there's rarely, if ever, proof of service. So in every instance, I really encourage you to have that filed. Reach out to the sheriff's office, get the proof of service, file it with the clerk. You can help facilitate that if they have not filed it with us, okay?
Okay.
Mr. Camba, anything else that you need the court to know today?
No, I haven't seen my son in over 2 months, and I'd like to see him effective immediately.
Okay, well, today I'm here on a motion for contempt. I'm not here on a motion to change visitation.
Well,
Talked
no,
about it.
so she took it upon herself to say that I was in contempt and just for existing in the same area when she showed up, and I left. So, I mean, this was already addressed to the court once, and I'm sure you remember that it was dissolved, and then now she's trying to bring it up again, and then on top of that, she's claiming that I served her paperwork.
And sir, all I can decide on are motions brought in front of me. There's nothing in front of me on this issue. Please file that, serve it on her, and make that request of the court. Okay?
She's avoiding being served, Your Honor, and you're well aware of this.
And then I'm not well aware of this. What I can tell you, Mr. Camba, is that you can file proof of 2 attempts at personal service, and then we can talk about alternative service, such as mail, email, social media, text messages, etc. But you have not filed proof of any attempts at personal service.
Okay, and then my response that was filed today or yesterday, sorry, that has to be served to her as well.
It does. Anything that we don't do trial by surprise in Washington. Anything that you are filing with the clerk needs to also be served on the other party, always, in every case.
Okay.
Okay. All right. Well, we have you all back on December 6th, Mr. Camba, on your motion for contempt. But again, right now, I don't have that proof of service. So just giving the party a heads up on that.
Yeah.
Okay.
Is there a way that we could set a time for that? We can do an exchange of papers, not myself personally, but I have somebody, a server, and so she could stop avoiding being served.
I cannot coordinate proof of service. So you will have to work on that with Ms. Camba or with the sheriff's office or with a process server.
Okay.
All right. Thank you both.
And also, in response to the contempt, like I said, I did file it yesterday.
I'm not hearing. I'm not going to hear any argument on the contempt. Sir, Mr. Camba, hasn't been served on you.
No.
Your response hasn't been served on her, and you haven't served your contempt on her. So I am going to end the hearing today. You all are scheduled to be back on December 6th. Please make sure I have proof of service.
Okay.
Thank you both.
Thank you.
Okay, number 5 on my list, Desiree Camba and Ruben Camba.
I'm here, Your Honor.
Okay. This is 213-0054208. Mr. Camba, I see you have your hand raised. Are you able to hear the court?
Oh, yeah, I was just making sure you seen that we were here. Thank you.
Yes. So on your case, this was originally, there's been a lot of service issues we have had on different cases. What we are here on today for 12-6 is This was set for Mr. Camba's contempt hearing against Desiree Camba. That declaration, I'm just looking to see when the service of that was made. Mr. Cambus, the affidavit I have on file is that the contempt hearing and the order for contempt, the declaration of Reuben Camba and Sabrina Clements was served on November 22, 2023.
Yeah, I believe that was by the sheriff's department.
Okay.
I went to the sheriff's.
You went to the sheriff's department?
Yep.
Okay. So that's about 14 days of service. We require 21. So it's not timely. Ms. Camba, it's up to you if you want to proceed today or set this over.
No, I would like to be done with this.
So I won't, and just to be clear, I won't be hearing your motion for contempt. The only thing on for today is Mr. Camba's motion for contempt. Do you want to move forward on that today?
Yeah, but don't you hear my declaration that I served him, or no?
Your responsive declaration to his contempt motion, yes, but I want to be very clear. I'm not hearing your contempt motion today.
Right.
This would only be his.
Right. So I'm okay with moving forward because his declaration is a lie and I have proof of it.
Okay. And then Mr. Camba, to confirm, can you go ahead and put your hand down, Mr. Camba?
No, I still had that. Sorry.
It's
There we
okay.
go.
I did it for you. Did you receive Ms. Camba's declaration in response to your motion for contempt?
Yeah.
Okay, so Mr. Camba, go ahead with what you want the court to know.
Well, as of like over 2 months ago, September 27th, I believe, Desiree has withheld visits from my son, claiming that I broke a restraining order, because, like I said in the paperwork, I was just merely in the same place as her, but I was there like 40 minutes prior. And then when she did show up, I did leave. So that was her thing of saying that I was contempt. And with that being said, she decided to take it into her own, she decided to keep my son from me since then. So that's why I've been trying to get into court, and we finally got her served, and hopefully she has some answers for us, because she hasn't made any attempts to reschedule any visits with my son. And I would like to move to unsupervised visits.
That's not what you're in front of the court for. You have filed a contempt motion. So
okay.
we are specifically here on whether it looks like your primary allegation is that she has incorrectly withheld visitation. Correct?
She has, yes, correct.
Okay.
Yeah, and we were in court before, and I believe you were the one that was addressing her saying that I was at the YMCA and that I did supposed things. And even though you clearly said that nothing happened because I left and I did the right thing, and then she's trying to bring it up again. So that's why I'm trying to move forward in this.
Mm-hmm. So I'm going to hear from her in just a second, but I need to be really clear. I think both parties are conflating a lot of issues. So there's separate issues here. It is, what should the overall visitation look like? That's a big issue in your case, but not before me today. What's been cited on for today is your contempt motion arguing
Yes.
that she has incorrectly withheld the children, but then you're also bringing in evidence about her allegations that you have violated a restraining order, which really relate to her untimely contempt motion that I am also not hearing today. So I just want to be really clear. Today is a very narrow hearing on whether I believe Ms. Kamba is in contempt. So I'm going to turn it over to you, Ms. Kamba, but I want you to be really narrowly tailoring your argument to the issue of whether you are not abiding by the parenting plan. And if you aren't, why not?
So I guess I am not abiding by the parenting plan, but in Ruben's statement in his declaration, which is an RCW 9A7202, he is committing perjury and said he had no idea of the no contact order, and he did. And so the reason I am not allowing him to be a part of Gabriel's life is because he again broke the no contact order.
So it was an amended to no contact.
No, just a minute. I'm going to go. So Ms. Kamba, you are saying that you are withholding visitation with the child. Is that still continuing?
Yes.
Is there any protection order in place between Mr. Kamba and the child?
Yes.
No, it's been modified for visits.
I sent everybody a copy of what the modification says. It says minor, third party, on the behalf of supervision, paragraph 6 and 7 and 8. It still protects contact between parties.
Hold on, I'm just going to pull that up. Which no contact order are you referring to, ma'am? What's the date?
Well, we got our original ones and then we modified them. This paperwork that I gave you guys all said that we all signed it May 9 of this year. His attorney, he had an attorney at the time. His name's Joshua Baldwin, was in that case.
This is the criminal no contact order. And it says there's a basis to modify the order of protection to allow visitation as set in the parenting plan.
My understanding was that I was allowed to contact my son. At that time, I didn't know exactly what happened because my attorney, he just said I could see him and then that's it. I wasn't told anything else.
Just a second, I'm trying to make sense of this because the only protection order, ma'am, that you're supplying to the court is from the criminal case. And
That's the only one we have.
Hold on, let me finish. That one says, hey, follow the family law parenting plan. And the civil protection orders, any civil protection orders involving the parties are dismissed. So the only one we have is the criminal one, and it says follow the family law case. So I guess I'm very confused why you're withholding visitation and thinking it's okay. So how
because
Ms. Kamba?
He broke the no contact order. He made a conscious decision, even in his paperwork. He says he saw us walk in, and then he refused to leave.
Who has decided that he broke the no contact order? A court or you?
A no contact order says he's not allowed to contact me or the child.
What? There is not a no contact order that says he can't contact the child.
Yes, it's only modified minor.
It's what?
It's modified minor that there is still a no contact order. It's still in place. It's just modified. Judge Hahn gave it to us.
The modification that I am reading is that Mr. Kamba is to follow the parenting plan under this case.
Right, which he did not. If he's making contact with a child that is not in supervised visits, that is breaking the no contact order. Says third party.
But, okay, so ma'am, why are you withholding the child from supervised visitation?
Because he broke the no contact order, and I've been trying to see a judge to figure out what happens because he broke the no contact order. But everybody keeps dismissing me. I got assaulted 2 years ago. My life has been hell because of this guy. He stalked me. He's almost made me lose my job. I don't know what else to do. I've been trying to get in front of a judge. So why does he get to see anything if he's done all of this and then broke the no contact order?
I am looking at his criminal history and I do not see any charges brought for violation of a no contact order. That would be a gross misdemeanor if he had done that. I don't see that.
He even admitted to it.
Ma'am, I need you, I can't understand you. Slow down and tell me exactly, you can't just take matters into your own hands and say, because I don't like something he did, I'm now not going to follow a court order. That's not what you do.
So he doesn't get to get punished for anything he does.
Ma'am, listen to me.
Do you think that's safe for my child to be with who already has behavior issues?
Ms. Camba, you have brought motions for contempt against him.
Yes.
They have not, hold on, ma'am, I'm going to mute you if you can't let me finish. You have brought motions for contempt against him, but you have not properly served them, so the court has not been able to hear that matter. You now are telling me that despite not having a ruling on that issue, despite there not being any sort of criminal charge for violation of a no contact order, that you believe you can withhold supervised visitation because you believe he came in contact with you and or the child. Is that what you're telling me?
I guess so.
Okay. Well, unfortunately, I have no choice but to find that you are willfully refusing to follow a parenting plan. The only remedy though that I am putting into place is that you must go back to the parenting plan that is in place. You cannot choose to withhold the child because you feel something went wrong. The parenting plan in place with supervised visitation needs to be followed. I'm not putting, hold on, I'm not putting any other penalties on you, punitive damages, anything like that. But I am finding that you have willfully withheld the child from supervised visits.
Okay.
You must bring the child to the professionally supervised visits.
Okay.
I am not issuing any monetary penalty, nor does it request me to do so. Mr. Camba is asking for makeup time. I'm crossing out that request and I'm indicating, who are you using for professional supervision?
Reconnecting families.
Okay. I'm going to put, how long, how many visits, Mr. Camba, have you missed with the child?
Probably like 8 or 9 at this point, Your Honor. And I'd like to see what it is that I could do to move forward and so that I could have unsupervised, because
Yeah, you'll have to wait, hold on. Like I said at the beginning, and not in front of me today, you all, as representing yourselves, would have to bring some sort of motion and note it on for a docket requesting a change in visitation. So feel free to do that. All I'm addressing today is the contempt, and I'm going to indicate that the makeup visitation to be scheduled with the professional supervisor according to their availability. Mr. Kamba, you had requested that I enter in this order that you move up to phase 2 and have unsupervised visits. I am declining to make that decision in a contempt motion. I'm going to go ahead and sign this document.
I have a question.
Go ahead, ma'am.
He's allowed to commit perjury in his declaration. How is that okay?
Ma'am, I'm not finding any evidence in front of me of perjury today.
I gave it to you.
All right, ma'am, I have signed the order. Please re-engage with professionally supervised visitation. You both are free to log out.
I have one question, Your Honor.
Is it about the contempt motion? I'm not going to hear any other matters.
Kinda. She's supposed to move out of my house, and I want to make sure that I'm gonna be able to know where she is, so when I do serve her paperwork, she's not just avoiding being served like she has been being in my house.
I can't facilitate that process on this docket. So I have handled the issue in front of me, which is the motion for contempt. You both are free to log out. I wish you both the best of luck.
Thank you.
Thank you.
So, as most of you know, I've been going through a domestic violence, and I'm going to say going. Even though I got assaulted 2 years ago, I've continuously been stopped, harassed, all kinds of fun stuff. I've had cinder blocks thrown through my window. I've had all 4 of my tires slashed. Okay, so I live in this, I don't know what we're going to call it, state of Washington, and I had legit evidence that my ex broke the no contact order, which, by the way, I also have a 10-year no contact order. They don't give those out for chump change. Okay, so I have a 10-year no contact order. My ex broke my no contact order. He also lied about knowing about the no contact order. Guess what happened today? The judge just dismissed it all, and then I get in trouble because I'm not following the parenting plan. Are you smoking crank? I cannot wait to get out of the state. I don't understand why they think this is okay, for one. And then for two, I also don't understand why they think that what I went through was nothing. And they wonder why nobody wants to report domestic violence because of this. I got in trouble.
Next matter is the Desiree Kamba and Ruben Kamba matter. This is cause number 213-54208. First off, a big thank you for your patience. Thank you. Desiree Kamba, are you on the line today? Ms. Kamba, if you're on the line, please make sure you're unmuted and state your name. I'm not hearing a response. There's no one in the courtroom. Ruben Kamba, you're on the line. I see. Can you hear me okay?
Hey, I could hear you all right, Your Honor.
All right. Thank you, Mr. Kamba. All right. We're here today on Mr. Kamba's motion for adequate cause finding on a parenting plan, to modify a parenting plan. Looking at the service that was effectuated by Mr. Kamba on Ms. Kamba. Looks like service was effectuated on the 17th of December. Does that sound right, Mr. Kamba?
Yes, Your Honor.
Okay. And so between then and now, if I count correctly, today, because on the 17th, we'd count 1, 2. Let's see, I've got the wrong year here. So when I counted it before, it was 16 days between then, the 17th of December, to today. And that needs to be 21, at least 20 days or 21 days, according to local court rule 88. So it says all domestic relation motions shall be filed and served upon all parties not later than 21 days before the time specified for the hearing.
So the documents were served on one day. It was on a Sunday. And then the say that that she was served, that document was turned in a few days later.
Yeah, good. I'm glad you raised that. Let's take a look here. So I'm looking at a document filed on December 18th, and it says, my name is Sabrina Clements. I'm not a party. I serve court documents on Desiree Kamba, giving the documents directly to her on December 17, 2023 at 10:45 a.m. at 1655 Hudson Street. And it included the change of a parenting plan, custody order, summons, notice of hearing, proposed parenting plan, and she signed it on the 17th. Is that the document you're referring to?
I'm not like her stating when it was submitted, yes.
Okay, so it looks like according to Ms. Clements, she gave all the documents to Ms. Kamba on December 17. So that still puts us shy of the 21-day period. So we're here too early, is what I'm trying to say.
Okay.
And so you're asking for some phase up time, and it's also some makeup time based on the earlier court ruling.
Yes, I was awarded makeup time because she was held in contempt.
Yes.
And I have still yet to see my son since she withheld.
Right. And then you submitted let's see, the date of this hearing was submitted for today. Yeah, I see that back in December. So she was given notice of today's hearing, being the 3rd of January at 9 a.m. She's not here. And so you gave notice of that. So she's not here. So the record will reflect that Ms. Kamba is not here. She was given notice of the hearing. We're here too soon. So what I'd like to do is set the matter over 1 week to January 10th. That'll get us beyond the 21 days. And then if she's not here at that time, then we'll take up, well, if she's here or not here, we'll take up your motion at that time. As far as going up to phase 2, having additional time, and also the makeup time during phase 2. And so, Mr. Campbell, what I'd like to do, and I apologize, it's taken us this long to get to your case for just a relatively short matter to address, but it's important. And so we'll set the matter over 1 week to January 10 at 9 o'clock in the morning for a continued hearing on your motion for adequate cause to adjust the parenting plan to allow for the phase up and the additional supervision, unsupervised visits in the makeup time.
Okay, is there anything that I have to do on my end?
Simply show up next week.
All right, thank you, Your Honor.
All right, thanks for your time. Next, I have Desiree Kamba and Ruben Kamba. Cause numbers 213-54208. Desiree Kamba, are you here today? Desiree Kamba? Right, not hearing a response from Ms. Kamba. And then Ruben Kamba, are you here today?
I am, Your Honor.
Okay, welcome to you, Mr. Kamba. So going back to Ms. Desiree Kamba, Ms. Kamba, if you're on the line today, I can't hear you if you are speaking, so I'd encourage you to unmute yourself. You can do that by pressing the mute icon on your device or computer, or you can simply press *6 if you're calling in with a phone number. So again, Desiree Kamba, are you here? All right, I'm not hearing a response. Back procedurally where we've been is that we were here last week on the 3rd of January. And I'm just gonna, I believe Mr. Kamba was here on that date. And I'm just gonna pull up and verify whether Ms. Kamba was. She was not. We set it over to today. And let me just look back here as far as service. Service of the documents was upon Ms. Kamba was effectuated on the 17th of December by Ms. Clements. And then it was noted for a hearing last week on the 3rd. There was some indication that
believe it wasn't within 21 days, Your Honor. So we moved it to this week.
Yes, yeah, that's right. Okay, so looks like service was proper for the documents. And so she received those documents, and there was a docket notice that was going to be noted for hearing last week. It wasn't, she was not present on that date, and she's not present today. So I have a proposed order that's been submitted by Mr. Kamba. That's an order on adequate cause to change or modify a parenting plan. And you're asking, I think, Mr. Kamba, if I'm correct, and you can correct me if I'm incorrect, is that there was a June 2nd, 2023 parenting plan order that has 4 phases of visitation. And you're asking that you move from the phase 1 to phase 2, which would mean 6 hours a week unsupervised, and do that for roughly 6 weeks or so. And that you're also asking for an additional 2 hours makeup time for the contempt, which was ruled upon back in December. And so that, so you're asking to move to phase 2, which would be 6 hours a week unsupervised, and that you're asking for makeup time to occur over that phase 2 time period, which would be roughly 2 to 3 hours added per week. Is that what you're asking for?
Correct. Also, with that being said, I haven't seen my son in over 3 months, and if she is not able to abide by the court, I'd like to ask if there's something that I could do in order to see about getting custody of my son, since she's not able to follow the court's orders.
So anytime there's a court order and one party feels that the other party is not following it or not abiding by the court's order, a party can bring a motion in front of the court. It could be a motion for contempt, saying, hey, this person has willfully not followed the court order. And then you can ask the court to make that finding and then make additional findings for possible change of custody or change in visitation. Another, so that's one option, is a motion for contempt. The other option is a motion for what you've kind of done here is that you've made a motion for adequate cause to change the parenting plan. You could make an additional motion to related to a change of custody. So those are your 2 options.
Would I have to do that? Could I do that today, or do I have to serve her with those documents? Because
You'd have to
she's
serve her
gonna,
with documents to change custody.
okay, because as it is now, it's she doesn't accept mail from anybody when I tried to have her served, so it was difficult enough getting this court situated for today.
Right.
So I'm just because she was held in contempt, and still, even after being held in contempt, I haven't seen my son. So I'm just wondering if I could just move to the next one and try to get that situated, because I haven't seen him, like I said, in over 3 months.
So I'm looking at the order of contempt from December 6th. It made a finding that she is withholding professionally supervised visits and impeding my forward motion in creating a relationship with my son. She's unwilling to bring my child to professionally supervised visits. She's falsely accused me of something and using that as an excuse to withhold the child. There's, so the court made a finding of contempt and then had ordered makeup visitation to be scheduled with a professional supervisor according to their availability. And that was the court's ruling. So those are your options. You could bring, basically you would be bringing a motion, and you can do that one of 2 ways. You could bring a motion for contempt because the court ordered that makeup visitation would be scheduled. If you feel that she hasn't followed that, you could file a motion for contempt for not following that. And then you could also make a motion related to change of custody.
And would I be able to do both of them together, or just
Good.
either one or the other?
You know, that's up to you, how you want to, how you want to address it. You could file one, you could file both. And you'd also have to serve her.
And as long as she's still at her current address, I just have it served to that address.
So I was noticing that you most recently served, or one of your helpers served her at the Hudson Street address.
Yes.
So, so there's different ways to effectuate service. You know, personal direct service is obviously the best. And so if that works, then do that. There's other ways to effectuate service, but you'd have to research that and do that.
Okay.
So for today, so I'm making a finding of adequate cause to modify the parenting plan to allow for going to phase 2 and then makeup time being granted. So I'm just going to write that into this order so it's a little more clear. And the record will reflect also that Ms. Camba did not file anything in opposition to Mr. Camba's request. Right, Mr. Camba, in your proposed order on adequate cause to change the parenting plan, I added the following in paragraph 5. It reads, Mr. Camba is permitted and does now move to phase 2 of the June 2nd, 2023 parenting plan order, which allows for 6 hours per week of unsupervised visitation. Additionally, Mr. Camba is granted makeup visitation for time he was denied with the child. Mr. Camba is granted 3 additional hours per week of makeup time while in phase 2. And I'm just going to add a parenthesis, unsupervised. So that order, I'll go ahead and sign that order now. And then, Mr. Camba, you've indicated that you have concerns related to not seeing your child. I gave you 2 options that you can address that would require service on her, and then we could take up that matter once you've docketed that and served her.
So, so in regards of getting something in line for me being able to see my son, I have to have the person Sabrina that I have documented that can do the exchange. Do I have her contact Desiree to set those up, or I'm just trying to see what my next steps are as far as me being able to see my son.
Are there any restraints on either party? Any restraining orders, no contact orders?
Yes, she has a restraining order on me.
Okay. So you need to contact her to make those arrangements, but you have an order that says you cannot contact her, correct?
Yes.
Do you have the cause number of that order in which the restraint comes from?
I have it probably in my stack of documents. I'd have to find it.
Okay, let me see if I can find it here brief. I'm just signing into my system. First name is spelled R-U-B-E-N.
Correct.
Does the no contact order come from a criminal case or a civil case?
I think it may be a civil case.
Let me go into a different system. Madam Clerk, are you finding anything? With my password to this other system is expired, so I can't look at that yet. Bear with us just one moment, Mr. Campbell. We're both looking at the different systems. So it looks like there was a no contact order entered on June 20th of 2023 in a criminal matter that the motion to modify. So it says the order protecting Desiree Kamba is modified to allow third-party contact to effectuate visits as said in phase 1 of the parenting plan in the case that we're dealing with today. Information between third parties must be made through our family wizard or through professional supervisor only. All other restraints of contact remain as set forth in the original protection order. So there's a specific carve out there, Mr. Kamba, where you can use a third party to contact Ms. Kamba to set up visitation. And apparently that needs to be done through the app, Our Family Wizard. Do you have that app?
I do not, but I can download it today.
Okay. So it's either through the Our Family Wizard app or through a professional supervisor that the contact is allowed to arrange for that visitation. And again, this is a June 20th, 2023 order modifying a protection order.
So I would have to download the Family Wizard app in hopes that she has it and be able to contact her with somebody else, or I could message her on there myself. I just want to make sure because I don't want to break the law.
Yeah, I'll read the language to you. It says this. It says the order protecting Desiree Kamba is modified to allow third-party contact to effectuate visits. Information between third parties must be made through Our Family Wizard or through professional supervisor only. So those are the two means of contacting her through a third party, is using Our Family Wizard or a professional supervisor.
And then when I sign up for the Our Family Wizard, is it gonna like appear that she's on there so that somebody else can message her for me?
I don't know.
I'm not.
I don't know. If the parenting plan, in this case, in the family law case, requires that, then I'm assuming there's a parenting plan from June 2nd, and I'll see if that has any language related to the Our Family Wizard app.
Because I'm not really sure how that works, and if she's not willing to come to court today, I don't know how I'd be able to communicate that with her. So that's the next that we're moving to the next phase and everything.
Yeah, so I'm looking at the June 2nd parenting plan. Under paragraph 14, says parents shall utilize Our Family Wizard to exchange information about the child. Reuben Kamba shall utilize a third party to avoid violating the protection order until the order expires in 2031. So the parenting plan requires both parties to use Our Family Wizard. So that's what the order requires, and that's how you should proceed. Either that, so those are your options: the Our Family Wizard or a professional supervisor.
Okay, so if I message her on Family Wizard, I won't get in trouble, or
the parenting plan says you have to use Our Family Wizard. The motion to modify the parenting plan in the criminal case says you have to have a third party send that message. And I don't know how that works because you sign up for the app under your name. So proceed cautiously, but that's kind of where you're at.
Okay. All right.
All right. All right. So Mr. Campbell, I've signed off on that order. I'll allow you to make what other future motions that you feel are appropriate to bring those forward to the court. And, you know, any information related to Our Family Wizard, your efforts to contact her through that third party and the third party app, you can bring that forward to the court and detail what's happening.
Okay.
Okay. I know that's less than satisfying. I can't give you legal advice. I can give you options. And so hopefully with those options, you can make an informed decision.
Des talk. Let's get real for a minute. So, sorry, I've been MIA. I've been driving across the country. Anyways, so, as I've noticed this drive, that other states have a lot of Walmarts. Literally, the state I'm in right now has, like, a Walmart on every corner. So, what is your guys' like, store that you guys have a lot of? Washington didn't seem to have a lot of Walmarts. But this state has a Walmart on every corner and a Target, so it's been different. How's it going in whatever state you're in?
Okay, thank you.
All right, that'll conclude the case for today. Thank you.
Thank you, Your Honor.
So Des Talk, let's get real for a minute. So I got a nice wake-up call this morning to find out that I'm on TikTok, and I didn't put myself on there, but they were talking about my court case against my ex. And that's kind of funny that people think that I'm just like not wanting him to be a dad. Dude, that guy choked me out, got my 1-year-old at the time tasered, and myself tasered. Then he threw a cinder block through my window. He stalks me, and I work for old people, and he has come to the old people's house and disabled people's house. But I'm a bad person because I keep him away from his child. No, I think you should look at his record, because I'm not the first one that he's got an accident from or an incident from, whatever you want to say. So he got an assault 2 for me, an assault 3, and an assault 4. All in one day. He also had another assault. This isn't his first time going around. He has another felony. He's an alcoholic, and he's bipolar. So maybe you should get educated before you go and say I'm a deadbeat mom and wouldn't want my son to have his dad. I would love for that, because I know what it's like to grow up in a single parent household. I didn't want this, but his dad doesn't want to get medicated, and he'd rather drink and get high all the time. So thanks. Get educated yourself before you start dishing out stuff, or go look up his record.
Next, I have the Desiree Kamba and Ruben Kamba, or Kamba, cause numbers 21-3-54208. Desiree Kamba, are you on the line today? Okay, not hearing a response. Ruben Kamba, are you on the line today?
I am, Your Honor.
Okay. Good morning, Mr. Kamba. So I'm not seeing Ms. Kamba here today, and so we're here today on your motion for contempt regarding the Family Wizard app and phase 2 and makeup time, and you haven't seen the child since September. One thing that's I noted in the service, looks like you used certified mail at the last known address of Ms. Kamba to notify her of today's motion. Is that correct?
Yeah, I had attempted personal service as well as mail.
Was the personal service successful?
No, she's no longer in the state. She had abandoned my house, and basically since she was appointed to just continue making the payments, and she just decided to stop making payments as of May, and then my house was getting foreclosed on, and she just up and took off to wherever she went.
Okay. So in the you asked for a motion to show cause. The court issued an order to show cause on January 19th. That order says, to the person requesting the order, that's you. It says you must have this order and the paperwork you filed with the court to get this order personally served on the other party by someone 18 or older who's not a party to the case. So here there's not personal service, it's substitute service by certified mail. So we're not, and the reason for that is that the contempt power allows for the court to impose leverage, if you will, sanctions on a person up to and including incarceration. And so that's why there needs to be personal service. So with that with the certified mail, I don't think that qualifies as personal service. Do you know where she's living that you could serve her?
No, she's left the state. And I got a letter in the mail from a random person stating that she left the state and that she has a YouTube channel, and she basically explaining, like, laughing about leaving the state and not having to worry about anything else anymore. I was awarded 9 hours of unsupervised visitation because she was withholding prior, and so, I mean, I don't really know how I'm supposed to serve her if she hasn't updated her address in the court and is just deciding to just ignore the court and just leave with my son and not allowing me to be a parent.
Yeah, you raised some important issues, Mr. Kamba. You mentioned that there was an effort to serve her personally, and I'm just looking for that. Just one second.
Yeah, if you would have looked at her YouTube channel, it just shows, how she's just laughing about the court and uh not thinking it's okay for me to see my son. It's not her choice.
Right, right.
There's a declaration of the server acceptable when no personal service attempts were successful.
See, that's what I was looking for. I was looking for attempts to serve her personally. That's what I was looking for. Do you know the dates of those, which they were filed?
Do I know the dates of what now?
When those declarations of attempted personal service were filed?
They were not filed, but they were done.
Okay. Yeah, so you're bringing up a lot of important points, Mr. Kamba. The fact of the matter is that the court, myself, ordered those 9 hours, and that you're now in phase 2 according to the parenting plan. And it's concerning to me that you have not seen your child since September, when there's an order in place that says you are to have visits with your child. The issue with the service is that all I know is that there was an attempt to serve via certified mail. That's inadequate unless there's some type of showing that would excuse personal service and say, well, this is the next best way to give notice to the individual, which, the mailing may be adequate, but there has to be first that initial showing that personal service was tried and it's not possible, or that there's a reason to justify excusing the personal service through some other means, such as certified mail. So it sounds like you have documents that pertain or are relevant to that issue. So I think what needs to happen is those need to be filed with the court so that the court can see that. And then one option would be to look at some type of motion related to alternative service being permitted. So that's kind of a long ways about to say that I can't rule on your motion for contempt today because service is inadequate at this point.
I have the person that Sabrina Clements that was doing all the serving with me. It wouldn't be adequate to have her just say that she did.
She'd need to file a declaration. That's kind of I kind of get what you're coming from. To have her, put her under oath and have her talk about it or say what she did or didn't do. Sometimes that might be the right course, but as a general rule, having things written down, documented, is the preferred method, and that's the method I would prefer.
So I would have to just have proof of attempts submitted in the court, and we can meet next Wednesday then. Or I just want to know what it is I could do because I haven't seen my son in so long.
I'm fine if we can set it over 1 week to the 21st of February at 9 a.m. and then you could file whatever documents related to service attempts and the like, and then we can address it next week.
Is there anything that I could be doing in particular to start the process of finding my kid? Like, do I have to find what's it called? Like a private investigator? I have no idea.
Yeah, it's those. That's an important and good question, Mr. Kamba. The court's in a position where the court's not permitted to give legal advice. The court can give options. I think probably one of your options would be you can check on, there's a website, you may be familiar with it already. It's washingtonlawhelp.org. Look into the family law section, and there can be some guidance there. There's some forms there also that relate to family law issues. That's one option. There's also the CLEAR hotline. The Clear Hotline is a line manned and womaned by attorneys that they're open during certain periods of the day. You can call and check with them and get some consultation from a legal advisor. And I can you can look that up just on the web. It's sponsored by Northwest Justice Project, but if you type in Clear Hotline, most search engines will pull that right up. So those are two options that you can look to find some answers about next steps in response to your question.
Yeah.
Okay. All right. So go ahead.
No, I'm just wondering what to do at this point, because, it's been almost 6 months since I've seen my son. And that's not because of something that I've done, it's what she's doing.
Right.
And
So I think those are two options that you can pursue, is calling the Clear Hotline, talking to an attorney, clarifying or laying out the situation that you're in, and then you can ask them what they suggest. That's one option. The WashingtonLawHelp.org is another that has resources about different situations that you can read up on, and has corresponding forms and orders that you can download.
okay.
All right. So we'll be back here next week related to the service issue. And then make sure that you file any documents that you want the court to see related to service.
Okay, thank you.
Okay, thanks, Mr. Campbell. Next, Desiree Kamba and Ruben Kamba, 213-54208 is the cause. Desiree Kamba, are you on the line, please? Ms. Kamba, if you're on the line, please state your name and make sure you're unmuted. All right, not hearing a response from Ms. Kamba. No one else is in the courtroom besides myself.
I'm here.
So this is a motion for contempt brought by Mr. Kamba, pardon me. And last time we were here, we talked about the service, and there was some certified mail, but it needs to be personal service. And I'm not sure if the personal service has been effectuated. I saw that there was efforts to do so on the 24th, 26th, the 3rd, and the 4th of February. But I didn't see the service had been accomplished. So maybe Mr. Campbell, you can give me an update.
So we tried serving her through mail. I've filled out some documents that would make that appropriate.
Okay.
And I was just waiting on a fee waiver signature for me to submit all the documents that I have. I have a very big packet.
Okay. So it sounds like what you're trying to do is you're making a motion for alternative types of service. Is that correct?
Yes.
Okay. So you're in process with that. And so then if that's approved, then you'd be able to serve through those alternative means. And then once service is completed, then we can address the motion, correct?
Yeah, but she's not in the state anymore. So, yeah.
And does she still have the child?
Yes, she does.
Okay. Have some options that you have. Sometimes those types of efforts are complicated. Some options that you might have to consult would be a website called WashingtonLawHelp.org. And then also the Clear Hotline. The Clear Hotline is a line staffed by attorneys in family law, and they can provide some assistance and guidance there on more complicated matters.
Okay. I believe I do have the proper documents. But like I said, I was waiting for the fee waiver for that.
Yeah, usually fee waivers, those are quickly and easily reviewed, and then once you get that back, then you could submit your request related to the service issue or the alternative service means. So I guess at this point, Mr. Kamba, with those issues pending, pending the an order allowing alternative service, do you have a request or what are your thoughts?
I just want my son back. That's all I really care about. Request that she brings him back to Washington immediately. I really, that's the only goal I have. I mean, she's done enough damage as it is. She's been in contempt for as long as I can remember now, like 5, well, not as long as I can remember, but like at least 5 months back.
Right.
So, she has to be stopped. You know, like I say everything in the documents that I'm going to submit. So I'm just waiting on the fee waiver for you to see all that she's done.
Okay. All right. So we'll let that run its course. It sounds like you'll get the fee waiver decision here shortly, and then you can submit your motion for alternative means of service for an order to serve in an alternative means. And then once you have that order, then you can make your service, you can effectuate service through those alternative means, and then you'd need to note it up on the docket for a date to address the next steps. And that's where I think those two reference or options I gave you, the WashingtonLawHelp.org website and also the CLEAR, CLEAR, CLEAR hotline, are going to be options for you to consider, just because out of state, bringing a child back, those matters tend to be a little more complicated, and without legal help, it's daunting. So those are options that you might explore.
Yes.
All right. So, Mr. Campbell, then, so we'll take care of reviewing the fee waiver, and then you'll then be submitting your motion. We'll give you a ruling on the motion for the alternative service means order. And then once that's completed, then you could note it up for a hearing, and having been informed by some of those options that I mentioned, the Washington Law Help and the CLEAR hotline. So does that give you and do you have any questions on next steps or?
Yeah, would I just like have to go to court next Wednesday after everything is submitted?
So you once you have your fee waiver decision, then you would, if you haven't already, you would submit the motion for alternative service means. Then you would have a ruling on that. Once you have a ruling on that, then you can effectuate service through that alternative means, then file the declaration or affidavit of service. Once you have that declaration of service, then that would be the time frame you'd note it up, because prior to that time, the court won't know if she's been served or not. So it wouldn't be effective use of the hearing because we wouldn't know if she'd been served or not. So once that you've effectuated service, then you'd note it up for the court for the next steps or any requested relief that you might have. Okay.
So no court next weekend. Next week, sorry.
No next week, because it would be premature. The motion and order for service, if that's approved, then you'd still need to effectuate that. And I don't think that's going to happen before next week. So once you have that in hand, that you've if the order is approved to serve in alternative means, then you'd need to effectuate service and then have it file an affidavit or declaration of service. And at that point, you'd note it up for the court to address the issue, because then at that point in time, the service would have been effectuated, and then that would give her an opportunity to respond. And and then we could have the hearing.
Yeah, because prior she had been served through the mail before.
We talked about that before, how with a contempt, you have to personally serve the individual unless you have an alternative service order.
Okay. I'm just hoping to see my kid before 2025.
Right. Okay, so that's kind of the thoughts I had on the different options that you might pursue.
Thank you so much, Your Honor.
All right. Thank you, Mr. Kamba. Desiree Kamba and Ruben Kamba, cause number is 213-54208. Or Desiree Kamba, if you're on the line, please state your name. Desiree Kamba. All right, there's no response. Ruben Kamba, are you on the line?
Yes, I'm here, Your Honor.
Okay. The record reflect that Ms. Kamba is not in the courtroom, and nor is she on the Zoom call. I typed in her name. She's not present and she didn't respond. Mr. Kamba, this is your motion related to adequate cause. Looks like service was proper upon Ms. Kamba. There is your motion for adequate cause is granted and your proposed parenting plan is granted. And I think you submitted some proposed orders, if I'm not mistaken.
Yes, Your Honor.
Yeah, let me find that here. Okay, so I see that here, an order on adequate cause to change a parenting plan. Let me just review that just a moment. And then did you submit a parenting plan also, Mr. Kamba?
I believe I did.
Okay, let me dig a little deeper. I've got quite a few documents in here, so let me make sure I have it. Oh, okay, good. Thanks, Madam Clerk. So, Mr. Kamba, is that, the clerk is indicating that the only document that she received as far as a proposed order was the order on adequate cause. And then we would need a separate parenting plan order. And I think, let me just pull it up here. I'm looking at this. You submitted one via, it's in the court file. You submitted it on February 22nd. Is that the document that you are hoping would be entered today as far as a parenting plan?
I believe so.
Oh, could you repeat that again?
I believe so.
Okay, thanks. So, so therein it says that you are the primary custodial parent. There's a limitation on Ms. Kamba that there needs, any visitation would have to be done with a supervisor, and it'd be from Sunday from 10 a.m. to noon. And that should be evaluated for mental illness and start and comply with treatment if recommended, that you have sole decision-making for school education and health care. And that her time is just limited to what we said before. The holiday schedule is the same as that Sunday schedule visit time. So that's the one that I have. Does that sound like the one that you're asking for?
Yes.
Okay. And I believe that's the same document that you mailed to her, correct?
Correct, Your Honor.
Okay. So what I can do, Mr. Kamba, once we're done here today, I can print up that filed proposed order of parenting plan order. And let's see, I'm going to put that as file 222 of 24 parenting plan. And then I will print that and then sign that, and then I'll have it filed. So I'm granting your motion for the adequate cause, and I'm granting your request for the parenting plan. One thing I wanted to ask you on the adequate cause order on paragraph 6 says the petition to change a parenting plan or custody will move on to a full hearing or trial. I don't think that's necessary because I'm signing off on the parenting plan here today. So I'm removing that and then just saying that there's no further hearing needed because I've signed off on the parenting plan.
Now my question, Your Honor, she ran with my son.
Yep.
So how about am I going to get my son back?
Yeah, it's a super important question, Mr. Kamba. The difficulty is that somebody who's not trained in the law, it's a cumbersome process, even for an attorney, and especially if the person's out of state with the child. I would strongly suggest you contact a lawyer. Some of your options include the CLEAR hotline. And I think I mentioned that to you before. I'm not sure if you did, but I can give you that phone number. Have you
Yeah.
contacted them?
Not yet, Your Honor. I just needed to get all the court paperwork in and everything done so that we knew what was going on.
Yeah. If you have a pen handy, I can give you the phone number.
Okay, yeah.
It's 1-888-201-1014. And they're not open 24/7. They have some limited hours, but you can call that. They also have if you type clear hotline in a web browser or search engine, it'll pull it up also, and it'll give you the times of when they're open. And it'll also give you some additional information about what's available. But it's a line that's staffed by licensed attorneys that can give you some assistance.
Okay.
Do you have any questions?
So, I mean, not really. Like, I thought this would like move forward into an assistance of me getting her back because she does have getting him back because she does have a restraining order on me.
Mm-hmm.
So,
Yes.
yeah.
Yeah. So at this point, the court has ordered that the child reside with you. And so the next step is getting the child back and getting the child back to you. And that's a process that's somewhat more involved. And I think you're probably wise to get in touch with an attorney to get some help on that.
Yeah, so the orders that you're signing today, I have to come in and get them right, so that I have proof that it was signed over and everything.
Yeah, you can get a copy of the order that's a sign. It'll probably be 2 or 3 days before you could pick it up, but you can get a copy of that, and that shows that a court of law has awarded custody to you, and that you're the proper custodian of the child. Then there's the next steps of one, finding the mother and the child. A next step of getting some type of an order to take the child and return the child. It's a very involved process. You need counsel.
Good morning. It's Does Talk. So it has come to my attention from people from my high school that my ex is reaching out to everyone, and not just my high school friends, people I go to church with, people who just know me. So if you know me, I'm really sorry. You will be getting a message. If you get a message, please call the Longview police. This is not the first time he's tried to hunt me down. And it's a violation of our no contact order. Now he is adding people from my high school, and that's not okay. And it's also a violation of our son's no contact order, so he is now breaking 2 no contact orders. So if you could, please call the Longview, Washington police, because this is nuts. This is just outrageously nuts. He needs to stay in his lane. I need to stay in my lane. Go over there and get yourself help, and maybe learn about children with disabilities before you come at me. Thank you.
Thank you, Your Honor.
All right. Thanks, Mr. Kama. Next is Desiree Kamba and Ruben Kamba, cause number 213-54208. Is Desiree Kamba on the line? Desiree Kamba, if you're in the courtroom, come up to the front and take a seat. If you're on the court call or on the Zoom call, if you could unmute and state your name. Okay, no response from Ms. Kamba. Ruben Kamba, are you on the line?
Yes, Your Honor, I'm here.
Okay, welcome to you, sir. So you're here today on your motion for contempt related to not seeing your child and concern that your child has left the state with the mother, correct?
Yes.
Okay. So one thing I wanted to double check, there was an order to show cause. You asked for a motion to cause Ms. Kamba to come to court and show cause why she should not be held in contempt. And you mailed that certified receipt on April 10th to her address in 4th Avenue in Kelso, the last known address. There was an order allowing service by mail entered on February 21st of 2024. And it allowed for service, it specifically allowed for service of a summons and petition to be served by mail. And so the mail that was sent on April 10th, have you received the certified return of that?
I believe so. I thought I submitted it to the court.
Just confirming with you. So Sabrina Clements assisted you with that. And then I show there's a receipt, certified mail receipt, with tracking. And did they give you a kind of, what was the outcome of that? What was the outcome of that? Did they serve it? Did they? Because sometimes they'll give a statement of like, on, such and such a date, we delivered it to the home.
Well, we send it certified, and then we send another one uncertified. The one that is certified gets sent to the home where she has lived, and then the other one that was being forwarded to where she's currently living, somewhere in, I think, Tucson, Arizona.
Did you submit that second one, the Arizona one? Did you submit an affidavit of mailing?
I don't believe, actually, a few, I think I did. I'm pretty sure I've submitted the receipts in all of them.
Okay. So
Because
I'm
it's
just
been a
looking,
long
I'm just looking
process.
through what I'm seeing is, let me see if this other document has the Arizona address on it. Yeah, what I'm seeing is I see the certified mailing on April 16th. Well, that's when it was filed and is mailed on April 10th. But I don't see the Arizona address on there, and I don't see a separate document showing mailing to the Arizona address. So, okay, so that's kind of where we're at with that. So at this point, do you
She's,
have, go ahead,
sorry.
go ahead.
I'd like for her to be found with the parental interference, and then for me to contact authorities, because that's the way that uh LVPD said that we'd be able to go about this.
Okay. So one question I had, Mr. Comba, when the documents were sent certified mail, uh, do we have a report from the post office stating that they mailed, or they took those documents to the address and mailed them and delivered them?
Yes, I believe they were sent to a PO box in Tucson, Arizona, and I do have the address saved somewhere on where the the where they were sent to. The receiving address, the receiving paperwork was signed by an employee that works in Tucson, Arizona, and I called like 40 different of the where they received the mail to find where exactly it was delivered. Because I looked up the employee's name, and then it said that he was an employee at can't remember what the business is called that receives mail. I'm sorry. And there's a PO box there for her.
Okay. Okay. So the one document I have in the court file, it relates to the certified mail that was mailed to the Kelso address for Ms. Kamba. There's a tracking number on there. There's a certified mail tracking number, return receipt tracking number. What I know is that it was dropped off and they estimated that it'd be delivered on April 12th. I don't have anything from the post office that says they actually delivered it. So that's where those tracking numbers come into play. There's tracking numbers that you can track that. There's the web address. And so what I know is that it was mailed, but the certified return receipt, it's unverified that they actually delivered it. Do you understand what I'm saying? Is it the loop hasn't been completed? The loop was started, it's come around, but it hasn't been completed because I don't know if the post office actually got the document to that address.
Okay.
And the
So-
document that you filed on April 16th has a tracking number on it, two different tracking numbers where they you can use that number, put it into the website, and then they'll let you know if it was delivered or not.
Okay, so what is it that we can do today if it wasn't, what is it that I have to do in order for us to move on in the court, because she's not going to respond anyways?
Right.
She
So
hasn't responded.
right. So it seems maybe hyper technical to say that, you know, the post office hasn't filed something that says they actually delivered it via the certified return receipt. So that needs to happen. I need to see some type of documentation from the post office that they in fact delivered that to the address in Kelso, which is accessible through their website with the tracking numbers that you had or submitted in the case file.
Okay, so I'd have to look it up and then submit whatever documents I find for the court.
Right. Right.
Would we be able to move this to next week?
I would like to move it to next week. However, next week is what we call judicial conference, where the majority of the judges are out at a conference for the week, and so we don't have a docket that next week, which is on the 1st. So the next available time, and I would be happy to set it on the 8th. It's kind of over full at this point, but I know that there's some timeliness concerns in this case, and so we can set it to May 8th. So if you can get that information submitted as quickly as possible, we'd be ready to review things on May 8th.
Okay, yeah, because it's almost his birthday, and you know, I've missed 4 of his birthdays. If I miss this birthday as well, and you know, I haven't seen him in like 8 months, so yeah.
Okay.
Thank you so
Right.
much.
So we'll be back on May 8th at 9 a.m.
All right, thank you, Your Honor.
Okay, thank you, Mr. Kamba. Desiree Kamba and Ruben Kamba, cause number 213-54208. The cause is Ruben Kamba on the line.
Your Honor.
All right, good morning, Mr. Kamba. And I'll ask if Desiree Kamba is on the line or present. All right, looking on the Zoom call list, I don't see anybody by the name of Desiree Kamba or anything similar. She's not responding verbally, and she's not in the courtroom. This is your motion for contempt, Mr. Kamba. I wanted to ask you, in service of the documents, it looks like there was an order allowing alternate service using a address, and that was an order that was entered in February. And it looks like you mailed the information related to today's hearing on April 12th. And then the question I had is, did you get any tracking information from the post office regarding whether Ms. Kamba had been served down in Arizona?
Attached the document, I believe, for the court that I did have, the receipt.
Yeah, I looked at that. Let me just pull it up again. That's kind of the basis of my question. So I'm looking at the okay, so April 16th, it looks like it was mailed to Ms. Campbell at the 4th Avenue address in Kelso. There was another document a little bit earlier that was sent on the 16th of April that, hold on, let me pull it up here. So, okay, it's coming back to me a little more clearly. When we were last here, Mr. Campbell, we talked about the tracking information and that you had checked the website using the tracking number to see if delivery had actually taken place. And I was curious, do you have any more information about that?
I do not. I just have that document that I submitted.
Yeah, okay, that shows the mailing that occurred to the South Fourth Avenue address, correct? You still there, Mr. Kamba?
Yes, I am.
Okay. I wasn't sure if you were looking for something or if you were waiting for me.
Oh, I was just waiting for you, Your Honor.
Okay, all right. So I think service is proper here because it looks like there was an order allowing alternate service by Mel, which uses the South Fourth Avenue address. And I think that's corroborated and supported also with her last pleading in the case file, which she filed, and she used the South Fourth Avenue address in Kelso. So the fact that you sent it there and there's service that shows that you did, there's been no response to your pleadings, and you're asking for a finding of contempt, a civil fine, and also jail time, and then a return of the child to you. That's what you're asking for, correct?
Correct, Your Honor.
Okay, you submitted a proposed order. Let me just take a quick look at that. I'm just adding on the second page, it's indicating that the court considered your motion for contempt, and we had a hearing on March 13th. I added to today's date and also April 24th. I'm just adding those two dates into that order. Then I'm just taking a look at the other dates. Mr. Kamba, I'm granting your motion for contempt. I am awarding the $500 civil penalty. Just making one change here, one moment. The last thing I'm considering, Mr. Kamba, is your paragraph 10, where it's requesting jail time in the amount of 365 days in the Calais County Jail. And that would be suspended under her bringing the child back to Washington.
And so if she doesn't willfully bring him back to Washington, she would get that?
That's what your proposal says. And I'm also going to, so let me just think about that for a moment. I'm also going to change paragraph 11 that talks about the purging condition, that I'm going to allow her to be able to purge the contempt finding if she complies with the parenting plan order and brings the child back to Washington.
And if she decides to just stay where she's at and hide, does this give me the ability to give this document to the police so that they can help me find my son?
As we've discussed in the past, Mr. Kamba, issues when a parent takes a child out of state and they don't return them are fairly complicated. There's means and methods that can be executed to bring a child back and get law enforcement involved. And that's why I suggested on a number of occasions for you to contact counsel, to get an attorney. I think I gave you options of contacting the CLEAR hotline. Again, I'd encourage you to contact the CLEAR hotline, and they can potentially give you some assistance on this, what I consider a relatively complicated matter. And then also they may be able to give you a referral to a local attorney that might be able to take the case also. So the issues of whether this order will suffice for law enforcement, I don't know. I've seen it done in the past with other attorneys, and it's pretty involved. So if somebody doing this on their own, since I can't give you legal advice, I can give you options. I'm giving you the strong option of contacting counsel and getting an attorney on board to help you.
Okay.
So let me just finalize the issue of the jail time. I'm going to change the jail time to 10 days. And that can be suspended under bringing the child back to Washington. So the hope is that, kind of a wake up call will help, but I've signed off on that order. You can get a copy of it. And we'll set a review hearing on the 22nd of May just to see if there's there's been any progress made with the attorney, and then if you need any additional, if you're making any additional requests, we can take those up at that time. So I'd really encourage you to get in touch with an attorney. The CLEAR hotline, CLEAR, just look it up on with a search, online search, and they should be able to give you some assistance. Any questions, Mr. Kamba?
No, thank you, Your Honor.
All right, we'll see you on the 22nd of May at 9 a.m.
Thank you.
Desiree Kamba and Ruben Kamba.
Good morning, Your Honor.
And we have Desiree Kamba. Okay, so there was a prior contempt finding when Ms. Kamba didn't appear. However, the motion was served by mail. There is an order allowing service by mail, but it only allowed service of the summons and petition, not a motion for contempt. It was limited in the order. So at this point, we don't have proper service on Ms. Kamba. You understand that, sir?
She's left the state and has been gone, and I haven't seen my son since like September. So, yeah, I don't really know. They just having me come back to see this, and I'd like to see my son, and I have custody of my son, but she's gone and is hiding with him, and yeah, so I'd like to see what it is that we can do about this, because
at this point, there is an order regarding the parenting plan, and if she has left the state without with the child, I'm going to suggest you contact the police. Right now, I can't do anything one way or the other until she's served with your contempt motion.
I did contact the police, Longview Police Department, and they said that they had to wait till court today. So just here to see what it is that's going to happen now that I am at court, what the next steps are, because like I said, I haven't seen my son in almost a year.
I understand that. As I said, there's a temporary parenting plan in place, but she hasn't been properly served with a motion for contempt. So I can't do anything in that regard, and I have to strike the prior finding of contempt. You understand that?
I'm supposed to serve her if she's gone.
I'm sorry?
How am I supposed to serve her if she's gone?
I understand what you're saying. I can't do anything in this civil case until she's served with it. That's why I suggest you contact the police at this point.
I did contact the police, and they said that we had court today. So
let them know what happened today. But unless and until she's served, I can't order her to do anything.
So I can't serve her by mail?
No, sir.
So how am I really don't understand, because you guys just have me coming.
If you don't, I can't do anything to her unless she's got notice of this hearing. You're telling me she's left the state and you don't know where she is. So that means we can't allow service by mail because we don't know where to mail it to.
Well,
so either you've got to have the police or investigator find her so we can serve her, or go through the police and see if they're willing to pursue matters. Those are the only options I've got for you.
So I did go to the police, and that's enough. I should just call the police department and let them know, hey, it's okay to find her now.
Let the police know what happened today. You understand?
Yeah.
All right.
So nothing happened today, right?
Yeah, I can't do anything because she hasn't been served, and you can't serve her because you don't know where she is. Let them know all that.
Okay.
Hey, it's Des Talk. Let's get real for a minute. So I love getting wonderful messages saying I'm a piece of shit. Fun fact is I never get these messages. Everybody else in the world gets them because the people who want to call me a piece of shit ain't got guts to say it to my face. Cool, whatever. Fun fact. I didn't wake up and be a piece of shit. I didn't say, hey, you know what, I'm born and I'm just gonna be a piece of shit. Nah! People do stuff and then I react. And I let the shit go. And I let the shit go until I don't. And then guess what? I'm a piece of shit. Oh, hell yeah, I'm a piece of shit. I'm the biggest piece of shit you're ever gonna meet. And I'm cool with that. Because I have to remember every day, what did you do to get me to this point? People go and say, oh man, you're so hard. You don't got no emotions. You ain't got no trust. You are so right. I also live with anxiety. Pain, trauma. It's fun. From all the wonderful people I allowed in my life, and they hurt me. Now, I'm not saying I'm going to be closed off, but what that person gets, they got to wonder what they did to me to get that, because I'll take ownership. Yeah, I'm a piece of shit. But what did you do to get me to this point? Can you answer that question? Can you be faithful? And if you can't, that's fine, because I know what you did. You know what you did. The good Lord knows what you did. And we all know you're going to do it again. It's just a matter of time, because those are your true colors. You don't like to go smooth sailing very long. And I can say that honestly because it wasn't just me. It was your other ex. It was your mom. It's your brother. It's going to be this girl. It's going to be those other kids. I'm just not allowing you to do it to mine. Thanks. Bye.
All right. Thank you, sir.
And Desiree Kamba and Ruben Kamba.
I'm here, Your Honor.
Okay, good morning, Mr. Kamba. Mr. Kamba, you're here today on a motion for contempt related to the non-return of your child. And I was just double checking when I was looking at the file yesterday. I was looking at service. Looks like there was an order allowing service by mail to occur at an address in Rochester. And did you file a return of service indicating that the documents were mailed to that particular address?
No, I was gonna see if we could move this to next week when I have the documents sent.
Okay. All right. So you're planning on mailing them this week sometime?
Yes.
Okay. Let's do this. The turnaround time between now, if you haven't already sent it, my preference would be to send it, set it to the 18th of September. That way, when you mail it, you'll generally allow 2 to 3 days for mailing. Say if you were to mail it today, then it would potentially arrive on Saturday. Well, maybe the 11th. Let me take a look at the 11th. Just one moment. We can do the 11th. Would you be able to mail that today?
Yes, Your Honor.
Okay, let's set it over 1 week. We'll set it over 1 week to the 11th of September at 9 o'clock.
Okay, thank you.
Great, we'll see you then. Thanks. We'll take one more before recalling the Cuevas matter. Desiree Kamba and Ruben Kamba, 213-54208. I'll ask if Desiree Kamba is on the line. Desiree Kamba? All right, no response. Ruben Kamba, are you on the line?
I'm here, Your Honor.
Okay, welcome to you, Mr. Kamba. All right, so Mr. Kamba, you filed looks like a motion for contempt related to the non-return of your child, and it looks like there was some issues related to service. I showed that there was an order to serve by mail that was signed off on, allowing for service at the Rochester address.
Right.
And then it looks like on September 10th, there was service by mail on September 4th to that address. And it looks like you sent it on September 4th, correct?
Correct.
All right. Just pulling up the case file, just a moment. Bear with me one moment. I'm just taking a quick look at the or local rule related to timing.
Also, Your Honor, I did pay for a private investigator to locate her, and I had the investigator give the detective that information.
Okay.
So there is a new address for her.
Which whereabouts, do you have a kind of a general idea or more specifically?
Tucson, Arizona.
In Tucson, okay. And then with that private investigator, if with kind of that tracking her down, has the private investigator been able to serve her with any documents?
I don't believe so. My concern is when she found out that I was getting custody of them, she moved out of state to begin with. And if somebody were to show up at her new apartment, she might decide to take off again, given the history of what she's been doing.
Right. Mr. Combo, in the past, we've talked about potential on your end, potentially getting in contact with legal aid or an attorney to help you in the process. Because we've talked about in the past how, you know, if she's withholding the child and ran with the child to a different state, there's certain steps that need to be taken and then presented to the court in order to get some type of order that would allow police to take her into custody. Have you made any contact with an attorney?
I did contact the free attorney that you guys have, but I haven't been able to really do anything with that. I think I'm gonna have to give them another call with all this new stuff and see if they can help me with that. But I mean, she's been in contempt this whole time. I haven't seen my son in it like a year. So,
Right.
yeah, I, I don't know.
Okay. All right, thank you. Just one moment. I'm going to take a look at that timing rule. So, Mr. Kamba, I know you've been working really hard on this case, and it's been taking way too long. The order to allow service by mail that was served on August 15th, I believe, was the date it was signed, and that date, in conjunction with today's date, would have been sufficient time under the rule if she would have been timely served. With the mailing of the document, it was mailed on the 4th of September to the Rochester address. That doesn't comport with the timing rule. So we're here a bit premature. I recognize that the services has been effectuated to that address. However, from the 4th of September to today, that's only 7 days, and there needs to be 21 days under that local rule. So what I'm suggesting, and I apologize for this, is to move the matter from today to 2 weeks from now, which would put it at September 25th, and that would be sufficient time under the rule. And if we haven't heard from her at that time, then I can go ahead and issue the contempt order that you're seeking. So do you have any comment or thoughts on that?
Yeah, the reason I sent it on the 4th was you said that it would be sufficient time for her to receive that paperwork for this week's court, since last week she wasn't able to go do it because she didn't receive the papers, obviously. So would
Yeah.
I be having to serve her address in Tucson is my question?
No, not necessarily. I mean, the service that there's a motion that allowed service via mail to the Rochester address, so that's sufficient. And if you can serve her in the Tucson, that gives her other opportunities to respond, and also kind of what you said also, that it potentially would encourage her to leave or relocate. So from my vantage point, if we set it over 2 weeks, there's proper service, and then we come back in 2 weeks, that allows enough time to have passed under the rule to allow for the court to enter your requested relief, barring her not responding.
So my question is, what would I need to send in the mail, or what would I need to serve her? Because Would it be just like the same papers again?
Well, so for the next hearing on the 25th, there's no further need of any service. If you are, it would be good to have in-person service on her, and have you could potentially serve a motion for another contempt, for the kind of continuing contempt or for withholding the child. And that would at least give her that personal service, and that gives a little more grip, if you will, to bring her to court and take the next steps potentially of asking police to bring her into custody and bring her and the child back home. So that's one thing you could do. You could note it up you could file a new motion for contempt for the new period of non-compliance, and you could serve her with that information. Otherwise, we'll just be back here on the 25th. And likely the motion for contempt would be granted at that time if she's not responded.
Okay, so I could still send that to her mother's address, a new motion for contempt.
Yes.
Okay.
Okay.
All right. Yeah.
So we'll be back on the 25th at 9 a.m.
All right. Thank you, Your Honor.
Great. Thank you, Mr. Kumba. Where we left off here. Next, if I could hear the call, the Kamba case, Desiree Kamba and Ruben Kamba, 213-54208. Ruben Kamba, are you on the line?
I am, Your Honor.
Okay, welcome to you, Mr. Kamba. I'll ask if Desiree Kamba is on the line. Desiree Kamba, if you're here, state your name. Okay, Ms. Kamba, I can't hear you, so if you are speaking, Desiree Kamba, make sure that you're unmuted and again, state your name, Desiree Kamba. We're not hearing a response. There's no movement in the courtroom, so she's not here in the courtroom. This is Mr. Kamba's motion for contempt. Service was mailed on August 27th to an alternate address, so service is proper upon Ms. Kamba. And this is related to a request for contempt for withholding of the child based on the June 2023 parenting plan, and that you're asking for costs of the $5,000 of private investigator fees. Can I just ask you, I'm inclined to grant you the contempt, Mr. Kamba. I wanted to ask you about the private investigator fees. Do you have any documentation related to that, as invoices or payments of anything of that nature?
He did send me a way to pay it online. I'd have to go to my bank and get a screenshot of the charge.
Mhm.
And it wasn't $5,000 for it. It was, I believe it was like $150 or $160. But all the other fees for like my process server and everything, she still has to get paid. It's taken a lot of work.
Okay,
So
so the private investigator say was about 150, 160.
mhm.
And then your process server fees, what of those? What total or what amount is that?
Well, it would be the rest. So about $4,000.
And do you have invoices related to that? Because generally, I'm not averse to awarding those fees. I just need some support or foundation for it.
I don't have an invoice for it, no. My process server, she is here in the court
Oh, she's in the car.
waiting also, and so
Oh, is she on Zoom? Did you say?
yes,
Okay, what's
yes.
her name?
Sabrina Clements.
Okay, Ms. Clements, are you on the line?
Yes, I'm here.
Ms. Clements, have you submitted an invoice for payment for your process service fees?
Not as of yet, but I can do an itemized list of that. It's just gonna take a little bit of time because I've been doing this since June of 23.
Okay.
When he lost the attorney, I picked up doing all documents and all services.
Do you have an estimate of what your fees are at this point?
I would say probably about, with my time of service and trying to research where she was in our area, probably about at least $3,000 with fees and time and drive time and all of that stuff.
Okay. Okay, so Mr. Kamba, I've read over, I'm familiar with your case and your motion and the concerns that you have related to not seeing your son for a significant period of time. So I'm granting your motion for contempt that the order of June 2nd, 2023 was not followed by Ms. Kamba in that she didn't follow the parenting time schedule and other parts of the custody order as you described in your motion for contempt. Making a finding that there is bad faith, that she's left the child apparently out of state, not allowing any visitation with father. And the issue as of the fees and the like I said, I'm inclined to grant that, but I need some type of documentation related to that. So what I'm putting there on the order, I'm putting reserved. Reserved means basically you can, if you bring back that documentation, then we can take a fresh look at it. So I'm just putting reserved upon a showing of documentation. I'm just writing that in the order. And I'm just going to make clear that it's not lawyer fees we're talking about. We're talking about a private investigator and process server. I'm just making that notation on both pages, so bear with me. So make that finding of contempt. Then in your proposed order, Mr. Kamba, you asked for 1,000 days in jail in the Calais County Jail. Is that correct?
Yes, and the reason being is she's choosing to take this time to do the most to keep him from me. Since it just yes.
So we've talked about this before, Mr. Kamba, the difficulty of her not being in the state and the child being with her. What I've traditionally have seen, and this is where I've encouraged you to reach out for legal assistance from an attorney. What I've seen in the past when a parent absconds or takes a child out of state in contravention or against a parenting plan court order, there's a long series of efforts that need to go into that to get a warrant issued and make it an interstate extraditable warrant, to get law enforcement involved. It's a fairly involved process. And that's why I encourage you again to seek out legal counsel to assist you in that process. Because at this point, yeah, I can order jail time, but it's not effectuated until she's here in front of the court. So I'm not going to order the jail time. I'm going to indicate that jail time is reserved. But again, just strongly encourage you to seek out legal counsel from an attorney to assist you in the process, because the ultimate goal, I think, is that if she's out of state, as you indicate, and she's withholding the child, then to get her back, if she's not going to come back willingly, then law enforcement would have to get involved and arrest her and bring her back along with the child. So that's an involved process, and it's takes some experience to get it and get it done right. So I'm signing off on the contempt order, and then again, I just encourage you to reach out to counsel to assist you with the next steps in order to get her here and the child back. So
Um,
go ahead.
from my understanding was I was just waiting for the prosecutor to re look at the paperwork and re put the warrant out for her arrest. And
Yeah, that's another option that a prosecutor could file a custodial interference charge and then seek a warrant, extraditable warrant. That's one option. There's a civil aspect too, that if you wanted to go that route, that's where my encouragement comes on that end.
yeah, I already she's already have that as far as parental interference. So but what I was saying was I was just waiting for the prosecuting attorney to re-put that.
Okay.
Unfortunately, they're on vacation until sometime mid-October. Tried contacting the prosecuting attorney that is currently handling, where the other person's missing out on because they're on vacation. And so I was wondering if that's all I'd be needing because I mean she's in contempt. There's a warrant for arrest. I found her address. Uh, is there like because I already contacted local police, so they're supposed to be contacting Tucson police
Okay.
to help with that. So
Yeah, so at this point, I think those are your two options. You can seek the assistance through a particular prosecution, or you can follow the suggestion of hiring private counsel to get some type of civil extraditable warrant. So at this point, I'll let you work through that. I've signed off on the contempt order, and that'll be filed. If you need a copy of it, you can check with the clerk's office. So that'll conclude the hearing for today. Thank you.
okay, thank you, Your Honor.